if the wife wants, what mediation is there? I hope you understand.
Yes.
Wife is the judge, decree holder as per Martinez versus.
Expert judgment.
Whatever.
The expert is
Whatever. Where is the other side?
Other side sample is there.
So what do you say, sir?
Chance may be taken for mediation.
The parties agree. Item 2, the memo लिखी दे दो. Though it is a money decree, but you are still agreeing for mediation.
No.
Because the piling up of mediation.
But Madam, clearly I am submitting.
So talk to your client. What Mr. is saying, what you are saying is correct. But let us not pile up the mediation without way ahead. हाँ. तो दुई 3 मिनट
3 टा मु प्रेयर करी
आपको नाम मैडम
चिन्मयी सुताराम
on behalf of HN Mahapatra for the petitioner.
मा 3 ने टिके प्रेयर
किया चली वाला
मा 3 ने मोर गोटा प्रेयर थिला.
And these matters, Mr. Misra and Mr. Samal, what is happening? Suppose you agree that immediately it can be disposed of. This amount, we agree. It has happened. In one matter, it is pending for 7 years, 5 years. They say it is 12,000. I agree for 10,000. Fair enough. So why to stay? Because the concern expressed by the court is that, Supreme Court is that maintenance matters are being kept pending without achieving any result. So that is, I don't know, of course, whether it's a maintenance matter, the registry doesn't know. Because when they are listing a WPC, they think it's a WPC. Other side, none. The matter has been listed.
Item 3, your lordship.
Under the heading, put कर देंगे. ऊपर जोड़ा bold लिखा है. In view of the adjournment sought for by the counsel of the petitioner, in absence of the counsel for the opposite party, the matters have been listed.
Item 3, I am there, my lord.
Mr. Samal, आपको date को पढ़े बैठा है.
It is from author 1 month back.
1 month रे कौन करेगा? This is not done, sir. We are listing for finding out cases for you after 6 years, 7 years. You are taking the 1 month time. List in the week commencing 30. 30 नहीं परिवार ना के बे? ना 6 30. Second लिखिए Mr. J.K. Mishra for the petitioner, Mr. Devasis Samal for the opposite party. The petition has been filed by the petitioner husband challenging the order passed by the Lord Judge Family Court Baleshwar in CP number 193 of 2016, in IN number 87 of 2016. So the CP was filed seeking CP was filed under section 13 of the section 9 or 13? 13 of the Hindu Marriage Act by the petitioner husband. The IA was filed under section 24 of the Hindu Marriage Act by the wife seeking interim parental like maintenance stuff. Both the learned counsel of the party submit that they will seek instruction for referring the matter to the mediation. So it is a case of maintenance. Though the matter is though the impugned order is direction for parental life maintenance. The learned counsel shall also obtain instruction regarding status of the CP number 193 of 2016 before pending pending before the Court of Family Judge Baleshwar. The registry shall instruction from the learned Family Judge Baleshwar regarding the present status of the CP number 193 of 2016. List in the week commencing 30 पहले ना 30 3 Third matter,
Malady in item 3.
last के continue कितना Mr. Mr.
Say the last tila 29
Seat किंतु हो?
आउ
7 वर्ष परे
लिस्ट हे ने पण
Sir, list ମୁଁ କାମ ନୁହଁ ସେଟା ଆପଣ list ନହେଲେ ଯେବେ ଆସିବ ମୁଁ କରିଦେବି.
till next date ଲେଖା
No, no, no. I will only observe that the interim order has lapsed. You must understand you are seeking modification of the order. So please don't do that. And I have some intelligence. After 7 years since it is not listed, so it depends on the order passed. If it is still further orders, it is further orders. If it is not until further orders, it lapsed.
it is for till next date.
Code লেখা is next day.
Order 29/5
20,000 deposit করছেন
ଆଜ୍ଞା
proof ଦେଖି ଦିଅନ୍ତୁ.
ଆଣିବି
ସେଟା ହବନି 7 ବର୍ଷ ପରେ ଆପଣ ଏଠି ଜାଣିନାହାନ୍ତି ନିଜେ କନଫିଡେଣ୍ଟଲି
ନେବି ଇନଷ୍ଟ୍ରକ୍ସନ ସେ ଯୋଉ
ଆପଣ କଣ୍ଡିସନାଲ ଅର୍ଡର ଦେଖିଛନ୍ତି
ଆଜ୍ଞା
ଅର୍ଡର ସେଠି ପଢନ୍ତୁ
ଆଜ୍ଞା
ଆଜ୍ଞା କଣ ଲେଖା ହେଇଛି ମଡେଲରେ ଅର୍ଡର ନମ୍ବର 3ଟା ପଢନ୍ତୁ
ପ୍ରିଣ୍ଟ କରିବେ
ହଁ ସେଟା କାହିଁ କହିଲେନି ଆପଣ ଆଗ you have paid complied and this is the affidavit or this is the memo. The order dated order number 3/29/5/2019 imposing a condition to the petitioner for depositing a rupees of 20,000. Stop. The counsel for petitioner does not have instruction whether the said condition has been complied with. It's an often instructor. MBW ହେଇଥିଲା ମାନେ ହେଇଥିବ ବୋଧେ ଆପଣ କହିନାହାନ୍ତି ଆଉ. You see how they're responding to a lawyer also. You get an order in his favor. He doesn't tell the lawyer whether he has complied. All like that? It imposed as a condition for the condition by the coordinate bench. He shall obtain instruction by the next date. যদি কহিবে তাহলে I will record your prayer and reject it that it cannot be extended. Yes. So it is submitted by the learned counsel, Mr. Misra, for the petitioner that though he has not obtained instruction regarding compliance of the interim order dated 29/5/2019, the said order should be extended. Interim order should be extended as the matter was not listed for the last 7 years. The prayer for extension of the interim order is rejected. Yes. Next. Yes, next.
My item 3 re, item 3, am I audible?
Yes, please.
Madam, I'm praying this may come along with WPC number 6203 of 2025.
Under the same heading.
My lord, it may come under the same heading, then your lordship will decide whether it should be sent for mediation or not.
And that ask your learned junior to file a memo.
My associate will file a memo, my lord.
Yes.
That is WPC.
Item 3, WPC 18941 of 2019.
May I just clarify one more thing?
Yes, please.
I'm not now making that submission since I'm making a prayer that the other case should come. There were a lot of efforts in the judge family court where the matter is pending for reconciliation. I think that has not been worked out. I'll find out that also and place it before lordship on the next date. Your lordship may kindly bring this case along with the present case.
Item 3. Petitioner none. Opposite party, Mr. Samir Kumar, Mr. Senior Advocate, along with
Chandrasekhar Padhi. He is here with me, your lordship.
Padhi, Chandrasekhar Padhi for the opposite party. But if it is maintenance, my understanding is that there can't be mediation regarding a grant of maintenance. They may agree like the other matter and even after the matter is listed, whether the condition is complied, that is not also instructed to the so because
I'm only praying if the both the cases comes up, I'll assist you.
let us see. Only. As per the petitioner, when the matter is called, The matter is pending since 2019 and has been listed under the heading. Somebody should have listed under the heading. The learned senior advocate appearing for the opposite party submits that another writ application involving the parties.
Yes.
WPC number
6203 of 2025.
6203 of 2025 is pending before this court, and this matter shall be may be listed along with the said matter. Stop. Para. Accordingly, the present writ application shall be listed along with say number type of
May I pray for next
heading
week?
number TRC team.
Can it be little earlier? Because what has happened in the other case, liberty was granted to me to take adjournments.
16 earlier 16
ଆଜ୍ଞା ମୁଁ କାହିଁକିନା ସେଇଟା ମେନସନ କରିଥିଲି ଆପଣଙ୍କ ପାଖରେ ଲିଷ୍ଟିଂ ପାଇଁ ଦି ଅଦର ମ୍ୟାଟର
କେବେ ଡେଟ୍ ହେଇଥିଲା ଏନି ଆଇଡିଆ
ଡେଟ୍ ଆସୁନି ଡେଟ୍ ଗଲାଣି ଭାରି ଡିଆରଙ୍କ ପାଖରେ ମେମୋ କରିଥିଲି
ଆପଣ ସେଟା ଭେରିଫାଇ କରିଦେବେ 16/3 ରେ ହେଇପାରିବ 16/3
ଆଜ୍ଞା ଆଜ ଲର୍ଡସିପ ପ୍ଲିଜ୍
କମେନ୍ସିଂ 16/3
ନାଇଁ
ସେ କହୁଛନ୍ତି ଯେ ଆପଣଙ୍କର ସେ ମେମୋ ଦେଇଥିଲେ ଲିଷ୍ଟ ହେଇନି ସେକେଣ୍ଡ ମ୍ୟାଟରଟା
ଆଜ୍ଞା ଆଜ୍ଞା
ୟେସ୍
ମାଇଲ
ଆଇଟମ 5 ଟା ଡାକି ଦିଅନ୍ତୁ ଆଇଟମ 5 କରୁନାହାନ୍ତି ଆପିୟର କରୁନାହାନ୍ତି ଆଉ ଥରେ କଲ୍ କରିଦିଅନ୍ତୁ ସେ ଅଛନ୍ତି ଆଇଟମ
5 please, my lords. My lords, proceedings, writ has been filed challenging the proceedings initiated under the Lokayuk by the Lokayuk, namely, my lords, proceeding number, Lokayuk proceeding number 670 of 2021, and challenging the vigilance case which has been initiated on the strength of the Lokayuk's order. Why order? The impugned order is this, my lords, at page 102, annexure 12. Can I take your lordships 2 minutes to read this order? It's a short cryptic order. If your lordship permits me, my lords, I'll read that order. None of the parties' appearance. No party appeared that day. 2, 3, and 1. Lordship may bear in mind that we are talking about BSQ 5 of my lords Bajabati. BSQ means Blackstone query. Order dated 2/3/2022. Lordship got that page 102.
Yes, I am there only one yes
Months. Grateful. None of the parties, none for the parties, nobody appeared in any of the parties. In the present complaint, it is alleged that rampant illegal mining of Blackstone is out in Bajavati Hills, Tahsil Dharmasala, District Jajpur, in collusion with district officials. In response to the notice, Collector Jajpur and Tahsildar Dharmasala have separately filed their replies. The Collector Jajpur in his replies admitted that the leaseholder of Bajavati BSQ number 1, 2, and 3 has illegally operated the mines of Blackstone beyond the boundary limit for which the penalty has been imposed on him. Be that as it may, the allegation of illegal mining made in the complaint could not be denied by the Collector Jajpur. We therefore, in exercise of our powers conferred under Section 20, subsection 1 of Orissa Lokayuk Act 2014, deem it proper to direct the Director of Vigilance Orissa to conduct a preliminary inquiry for ascertaining whether there exists any prima facie case for proceeding further in the matter against the public servant or any other persons. Needless to mention, the Director of Vigilance shall ensure compliance of provisions of Section 20, subsection 2 of the Act. The report of the preliminary inquiry to be submitted within 2 months. A copy of the complaint and all relevant documents being immediately supplied to the Director of Vigilance is this matter. Now, your lordship, next day, after pursuant to that, not on the next day, pursuant to that matter, on 9/6/2022, this order was passed to 2/3/2022. Then on 9/6/2022, I get a, my lords, notice from the vigilance cell in vigilance file number 5 of 2022 arising out of local case number 670. Now I am talking about you have been allotted with Bajavati number BSQ number 6 on lease, on allegation of illegal mining of Blackstone quarry in the Vajapati Hills under Tahsil noted Lokayukt case has been initiated and inquired into. You have been allocated with Vajapati BSK number 6 on lease for extraction of Blackstone. Your examination is required in connection with mining operation in Vajapati BSK number 5. You are therefore hereby intimated to attend. Now, this is the first date I get any wind of the fact at all that any inquiry has been launched against me. 1. 2, my lords, I am not even a party to the proceedings. I have never been impleaded by the Lokayukt. Once the collector and the Tahsildar Dharmasala, they file an affidavit that illegal mining is going on. Now, and a normal course of things, the Lokayukt should have impleaded me in pursuance of rules 21, section 21.
Wow, Mr.
The
Pandit,
Lokayukt should have been.
may I ask you, because I'm struggling with the facts. Where is the affidavit referred to by the local Honorable Lokayukta? Does
We
he
could
refer
not
to
get
any
that. We could not
affidavit?
obtain that copy.
Sorry?
No, and even in that your lordship affidavit obviously must not be referring to this thing because the order does not
Which
reflect my
affidavit-
query
Which
also.
affidavit the Honorable Lokayukta has referred and how he has arrived at this conclusion? Because at least,
That's the exactly that is the point. That is the point. We are not getting.
No, because
That is the point. And the order
the
only.
struggle with the facts is that is there any procedure prescribed for the Honorable Lokayukta to pass orders?
Lokayukta Act is there, my lord. So your lordship must be familiar with that act. Lokayukta Act 2014, section 21. Persons likely to be prejudicially affected to be heard. Section 21 of the Act clearly says, if at any stage.
This one statement, may I? Once I attended a inquiry.
My lords.
Mr. Ramjet Malani, the great, he just said this one sentence that the person has not been heard. He said nothing. He said nothing beyond that. He just came, brought to the court, sat and. So I think that is the law we have read and I understand. So that is how, I don't know what order ultimately judicial law. I must find out what is the. So what according to you, where is the affidavit or what is relied on by the this?
That your lordship may call for that record. Your lordship may call for that record. No difficulty there.
But
this is absolutely
doesn't have.
Man, I'm not even a party, my lords. Nobody is giving me anything. Unless I'm not been impleaded. And this is a clear case of procedural abomination, not even an aberration. It's an abomination of procedure. How can you launch a proceeding against me without even hearing me on the strength of some affidavits filed by the collector and the Tahsildar? Basic minimum requirement is I should have been caused.
You are reading. Actually, your voice is somehow this audio is not quality.
I'm sorry, my lord.
You are reading the act you referred to.
So section 21. Persons likely to be prejudicially affected to be heard if at any stage of the proceeding the Lokayukt considers it necessary to inquire into the conduct of any person other than the accused, or is of opinion that the reputation of any person other than the accused is likely to be prejudicially affected by the preliminary inquiry, it shall give to that person a reasonable opportunity of being heard in the preliminary inquiry and to produce evidence in his defense consistent with the principles of natural justice. I am going one step further. Even prior to that, Lokayukt has to hear me. Only thereafter he has to send me. After hearing me, if he is not convinced, then he will say, all right, you go to the preliminary inquiry and satisfy them that you have nothing to do. Is
it that pursuant to the direction of the Lokayukta without hearing anyone? Kindly just appreciate this. Is it that pursuant to the direction the Lokayukta has the power, Honorable Lokayukta has the power to issue direction against anyone without hearing him for preliminary inquiry?
No. It's an abomination, cannot be done. No law will mandate that. When the section is clear.
My question is like this: suppose Honorable Lokayukta directs vigilance. So when they can conduct an inquiry, anyone against anyone, or the Lokayukta has to specify.
No, they can conduct, but there's a rider there. It has to be based on some sort of a complaint there. If some material comes, then immediately the Lokayukt has to hear, ask that person, and then direct him to go to the inquiry. He cannot straight away. And here also,
Any copy of the representation or complaint before the Lokayukta.
well, that is I think first annexure. Huh? I'm sorry. Annexure quote. Lakshmi, just give me a minute. Good.
62, page 62.
I think
Page
it is
62.
60,
Page 62.
62 is
Right.
some notice. 62 is the notice, I think.
No. 62 is 61 is the notice in the office, the complaint lodge notice, and 62 is the complaint. The so-called youth leader, BJD social worker, and organizing secretary, these are all very vague. And now this has become, with great respect, mallards, and off the record, this has become an engine for blackmail mallards. For anything one approaches and there's a whole statutory machinery, your lordship is familiar, that rules of mining rules.
Obviously, anyone committing a crime cannot be prevented by doing something wrong. That's I'm conscious what you are saying, because and much less the high office of the
No.
Lokayukta. So suppose I start beating someone because who is committing a crime.
Mallard.
Let us say
The arms of the law.
Ask Mr. Lenka that you start beating the person, he is committing a crime.
Mallards,
I'm a
exactly.
High Court judge. Lenka has power because he will inform the police.
Mallards,
But the issue is, Mr. Lenka may ask me, looking the way he that your lordship has power to direct that.
Your lordship could not have put it. I could not have put it better than your lordship,
I
Mallards.
don't know actually, so because
And these are fundamental issues.
my effort is that anything is there which you have not noticed or I have not noticed, which is actually there.
Even if I have to be heard at least. No man can be condemned unheard. There is a fundamental tenet.
Who is to appear? Because now the question is that, of course, the Lokayukta orders. That's my determination. But who is handling in a lower court? The registrar handles these things.
No, I think, my lord, there is some dispute regarding that. Your lordship may issue notice in the normal course. Sometimes earlier, what happened, my lord, there was a case, there was an issue where the Lokayukt appeared suo moto through some lawyer, through some counsel. So, my lord, the division bench took umbrage of the fact and said that Lokayukt cannot be contested.
Is it that incident which I witnessed as a lawyer almost 15 years back?
Possibly.
Because
So then that matter went, Justice Muralidhar said, Honorable Justice Muralidhar said that this is not proper conduct on behalf of the.
That I have seen. Prior to that, Justice R.K. Patro was presiding that.
And that went to Supreme Court. Eventually, Supreme Court said, no, Lokayukt also has to have some representation. But Lokayukt cannot be.
That matter, I was appearing.
Yes, as a state counsel.
I have seen the kind of exchanges. The great Gangadhar Rath was appearing actually. So that I still remember. Lot of it was generated. The court asked this type of what, but this is something very procedural.
Mallards. This is a complete, if I may dare to use the expression, abomination of procedure, not a mere aberration which can be rectifiable. I'm not, your lordship is not audible, Mallards. I think the voice is cut off for some reason.
Mr. Lenka, something, Mr. Learned AG, I'm discussing something.
No, no.
So, since Subir Palit, senior advocate, along with
Miss Ananya Pradhan.
Ms. Ananya Pradhan for the petitioner. Mr. Opposite party के नाम दिए. The petitioner is before this court challenging the vigilance cell file number 0502.
Pursuant to the order of the local dated 672.
Order dated 02.03.2022 passed by the Hon'Ble Local Orissa in case number Y-670/2021. The Lord Senior Advocate refers to the order. Lord Senior Counsel for the petitioner refers to the order dated 2/3/2022, which is reproduced herein. Stop referring to the said order. It is submitted that the Honorable Lokayukta has not referred to any person named though he has referred to the complaint could not be denied by the though it has been observed. Refer to no, though stop query, though it has been observed. Quote, be that as it may, to Neki by the collector, denied by the collector, Jajpur. Stop. Since I not, then quote ends. But the documents, oblique affidavit, oblique report furnished by the collector, neither has been referred, nor any further details have been given. Stop. The Lord Senior Counsel refers to section 20.
21. Section 21.
20 into bracket 1 or 21?
No. 21.
Section 21 of the Lokopal and Lokayuktas Act, 2013.
But it's Lokayukta Act, not Lokopal. Lokayukta Act 2014.
Odisha Lokayukta Act is perimetry actually. That is how I got it.
Yes, man.
Both the perimetry provision, so that is how it matches also. Section by section it is matching. Odisha
Same
Lokayukta
section
Act,
is there, same
2014.
Same sections.
Section 21, which is reproduced here. This direction for vigilance inquiry is which section? 21 Code Cordon.
20. Section 20.
Then the Lord Senior Counsel refers to the section 20,
Well,
which requires procedure in respect of preliminary inquiry and investigation. But it is submitted that harmonious reading of sections 20 and 21 would lead to a irresistible conclusion that the person affected needs to be heard by the Honorable Lokayukta if he is going to pass, if any order is to be passed which prejudicially affects the person. Stop. This further submitted. The present petitioner was never a party before the Lokayukta. Stop. Stop, no, comma, much less being allowed any opportunity, much less being given any opportunity to be heard regarding any issue that was part of the complaint made before the Lokayukta. जोटा पढ़िले से ओडिया एटा जोटा कोठी तार तार इंग्लिश ट्रांसलेशन टा देबे
आज्ञा
जोटा
मु दे देबे
पेज केते 62 कहले
62 sir.
The letter senior counsel then refers to page 62 of the brief, which though contains the address of the sender who has been implemented as OP number 3 in the present application. The narrations are in vernacular Odia. The Learned Counsel submits that he shall file English translation of the said vernacular said document in vernacular Odia. This court being able to go through the said documents, said document, being able to read and understand Odia. The learned senior advocate drawing attention to this, the page 62 submits that the complaint does not indicate any name or any particular person apart from making allegations in general. भी कराई से भी आपण तो आवश्यक कार्य ग्रहण करना अधिकारी को उत्तरदायी करा जाए आवश्यक दृढ़ कार्यानुष्ठान ग्रहण करा जाए अधिकारी किसी लिखिले एथिपे राजस्व विभाग खनि परिवेश विभाग सर्वोच्च अधिकारी को पक्ष करा जिबा सहित even that also okay. In general, stop. But issue notice along with this order to the opposite parties. Notice to the OP number 1, office of the Hon'Ble Lokayukta represented through its secretary is only to the extent for obtaining copy of the records, copies of the records. Those were part of the proceeding before the Hon'Ble Lokayukta. Proceeding number kichi achi?
Proceeding number 670 of 2022. 2021.
670 of 2021. Issue notice to OP number 2 and 3 by speed post with registration and proof of delivery. Requisites for issuance of notice be filed within 3 working days.
3 working by Monday.
3 working Monday is one first day.
3 working days.
3 working days.
Great. Straight.
Now what is the IA?
IA manors, one is stay and second is dispensing with filing a certified copy because we are not parties. They did not give us the certified copies also.
तो first IA लिखिए 5515. ये जो order पूर्व IA number 15515 of 2023 has been filed seeking dispensation of filing of certified copy of the order impugned. Stop. The senior advocate on behalf of the petitioner submits that He has never been a party before the Honorable Lokayukta in the proceeding, nor he has been provided with any copy. For the time being, the filing of certified copy may be dispensed with. The prayer is allowed. In view of the filing of the attested copy of the order dated so and so, the filing of certified copy is dispensed with for the time being.
Stay is 5514.
To stay means what stay?
Stay of the operation of the order, vigilance proceeding. Further proceeding against me.
Or the authorities are not to proceed against you.
Yes, cannot proceed against me. That's the prayer I've made. Please to grant a stay on the operation of vigilance proceeding against the petitioner by vigilance file number so and so arising out of
After the vigilance has sent you a notice.
My lords.
Thereafter what happened?
I've attended on
So you are
2
referring
days.
to that only. Okay. Till the next date. 5514.
5514.
5514 of 2023.
23.
Hard Learned Counsel for the Learned Senior Advocate for the petitioner. He reiterates his submissions as noted above. You should notice along with this order. Notice to the opposite parties 2 and 3 by speed post with registration and proof of delivery. Accept one set of process fee as well as postal requisites along with the writ application. As an interim measure, it is directed that there shall be stay of operation of the vigilance proceeding against the petitioner with a vigilance cell file number 05/2022 arising out of the impugned order dated 02/03/2022 in L.Y. number 670 of 2021 in the next date of hearing.
Great.
Just in the week commencing 13/4/2026.
Grateful. Urgent copy of your lordship.
Liberty to mention. Urgent certified copy as per rules. But why it is kept pending since 2023?
No, for some reason, my lords, it could not be listed.
Yeah,
Lokayut is also not there.
So
Nobody
that
has
was-
been appointed.
So that was the reason perhaps I was asking you that why now? Why suddenly?
No, because before he left, he passed this order and went out. And then he retired.
No, that happens with government servants before retirement. That theory should not be applied here.
No. This order was passed coincidentally just before retirement.
Yes.
Since then, nobody has appointed.
That was at the cost of yours. I mean, yourself. I said something. So in a lighter way.
I understand, but I take it. I already understood it.
Yes.
Grateful.
बंद कर ले.
I'm sorry.
नहीं कि मेंशन कॉल ना तो डाकी दो साथ दियो. I didn't should have order डाकी ली भूली गए. ठीक है.
तो फोर्थ
Sorry sir.
ऐसे फोर्थ का
Item 4 पे डाकी ना.
Item 4,
Last time also he was absent. I think he is not.
The writ application was presented before this court. Para one of the order number one. है ना? तब लिखिए, when the matter was listed on 24/2/2026, the following order was passed. Para 2 ta quote करते हैं. What has the registry intimated the learned counsel? Okay. As per the office note put up by the
Yes.
as per the office note put up by the registry dated 6/3/2026. In compliance of the order number, state order number 1 dated 24/2/26. The learned counsel for the petitioner was intimated regarding the next date of listing. Stop. The cause list also indicates that the matter shall be disposed of without further adjournment. Stop. Today, when the matter is called, none appears for the petitioner. Apparently, the petitioner has lost interest in prosecuting the matter. Anything else, Mr. Lanka?
And that's what.
The matter stands dismissed. The writ application stands dismissed. Yes, next.
Item 6.
Mr. Bhavani Shankar Panigrahi for the matter. Petitioner. Yes, please.
Well, the proceeding arises out of a application on Section 9 of the Hindu Marriage Act. The original proceeding has already disposed of in the meantime. Therefore, it has become infructuous.
Kindly file that memo.
Yes, I am filing that.
The petitioner wife in the marriage is the petitioner before this court. Stop. By filing the petition, she had challenged the order dated 12/12/2023. Passed by the learned judge Family Court, Raukela, in civil proceeding number 268 of 2015. The prayer was for summoning 6 witnesses
My lord.
by the said order. The prayer of the petitioner to call 6 witnesses for examination on her behalf was rejected on the ground that the matter was pending since 2015. And adopting such course of calling more witnesses would delay the matter. The learned counsel for the petitioner files memo of date तारीख दिन ଆପଣ କଣ ଏମିତି କରୁଛନ୍ତି?
I am sorry, my lord.
ପ୍ଲେସ୍ ଡେଟ୍ ରଖିବେ ନା?
My lord.
Which indicates the following. Which indicates thus. Stop. The memo shall be taken on record. Scan copy be updated. The petition stands disposed of. That receive କରିକି ତ ଲଗେଇବେ ସେ file ରେ. Yes, please. Next, call the list.
7.
Item 7, your lord, sir, was short pass over maybe.
Okay. Yes, please. Next. Mr. Sakti Sekhar for the petitioner. Mr. Mr. Lenka or Mr. Mahanti?
8 I am.
So PK Mahanti as the standing counsel for the next matter can be taken up. Mr. Your matter can be taken up.
Lordship के साथ custody
Oh, acha. Sorry, I thought that you are thinking that I have. No. I read your face. I thought that at times we do face reading also. No, boy. Let's say in a lighter way. Let us Shakti Sekhar for the petitioner, Mr. P.K. Mahanti AC for the opposite party. The petitioner alleges non-compliance of the order dated dash, fasting dash. The learned additional standing counsel upon advance copy served appears and submits that he shall obtain instruction in the matter.
No, my lord, already instruction has come.
Acha, he has
From
received
the,
instruction in the matter.
From the district education officer that funds have been called for the payment of the area salary, ma'am. But here is the,
You file that affidavit because it's a contempt. You must understand that.
Ma'am.
The person has some, he may face adverse orders. So be careful in it. So now suppose you file the instruction, he files. Later he said that I never instructed to list on record. Those complications should always happen.
No, similar contempt case. The lordship has fixed.
Sorry, no, he has already, after that they have started moving.
Your lordship has actually directed for obtaining instruction regarding compliance of the order.
Instruction in the matter by letter from the
district education officer, my lord.
district education officer dated
Dated 27/2/2026.
27/2/2026.
Letter number is 2551.
Leave it. Leave it. Upon pilot the letter 27/2/2026 indicating that steps have been taken for
the release of the area salary.
release of the arrear salary.
My lord.
And he seeks stuff.
Funds have been called for to release of.
Okay, steps have been taken and funds have been allocation of funds have been sought for. Stop. He submits that given some time the order will be complied with.
Ma'am.
Stop. Accordingly, the matter shall be listed in the week commencing.
May I pray for 6th of March because the other contempt case is also listed on that day.
ଶୁଣନ୍ତୁ ଯୋଉଟା କମ୍ପ୍ଲେନ୍ କମ୍ପ୍ଲାଏ ହେଉଛି ସେଟା କମ୍ପ୍ଲାଏ ହେଇଯାଉ ତାଙ୍କ ଭାଗ୍ୟ ଆଙ୍କ ଭାଗ୍ୟ ସେଟା that is the principle seniors have told us ସବୁ କେସରେ ଗୋଟେ ଭାଗ୍ୟ ଥାଏ ସେ ପଇସା ପାଇଗଲେ ସେ ଯିବେ ତା ଭିତରେ ଆକୁ କାହିଁ ମିଶଉଛନ୍ତି ଯିବେ ଆପଣଙ୍କୁ କିଛି ଫିସ୍ ବି ଦେବେ ସେଥିରେ
In terms of data ko ye, in terms of
ମତେ ଲାଗୁଛି ସେଇଥିପାଇଁ ହେଇଛି actually ଆପଣ ଯୋଉ ଆରଟାରେ ଇସ୍ୟୁ ନୋଟିସ୍ ହେଇଗଲା ସେଥିପାଇଁ ଏଥିରେ ସେମାନେ ଆଡ୍ କରିଦେଲେ ପେଣ୍ଡିଂ ଯୋଉଟା ସେଟା ସେଇ ମ୍ୟାଟର ଯୋଉଥିରେ ସୁପ୍ରିମକୋର୍ଟ ହାରିଯାଇଛନ୍ତି
Already the pay fixation from 2003 is done. They are getting their
But from reading faces also, I remember little thing also.
Yes.
So, list in the week commencing, केबे का आपण बोलछन मिस्टर आपण लेटर रे केते दिन मागछन
Are not paid. Reasonable time dimas कोन
ठीक अछि दिमाग नियंत्रण
सेटा बहुत बड़ा
एइने कोनतु एउडा कर आपण स्टोर करन
आगे batch of matters sir.
This is 2020 format, ruthless format. So आपण जते स्कोर करिवे सेते भलो
एतरे सब 2024 ପରେ एंटाइटलमेंट डिसाइड हे
आपण से जो हमर स्टार बैट्समैन और स्टार बॉलर ଦୁଇ ଜଣ ଜାକ फेलियर सेमति करन
मैनेजिंग कमिटी ताको जो एडजस्ट करिवो 4th to 3rd
एटा आपण जो सुप्रीम कोर्ट करे आपण से ताकू जहा पैसा दे आपण काम सार दियंतु से मैनेजिंग कमिटी बुझा बुझी हेबे तापर से शक्ति सेकंड कर
हिसाब
तो से आउरी केस चालुबो आपण को आपण इन्वेस्टमेंट करबे
हिसाब ऑन द डेट ऑफ एडजस्टमेंट
जल्दी करो don't use your time. You must understand.
Yes.
By concentrating on by spending time on a case where Supreme Court order is there.
Yes.
I mean, all of us are wasting time.
Then all should are okay.
In fact, they are now committing contempt of Supreme Court order, which basically is a difficult area for this court also. In the week commencing, in the week commencing 6/4/2026.
Yes, madam.
Did you कर दियंतु
Item 9.
डेट कर दो
May I please, your lord? My lord, I am in virtual mode, my lord.
Item 10.
My lord, item 9, your lord.
Sorry, Mr. Rajiv Patnaik for the petition. No, you are Mr. 9. Mr. Patnaik, you are for
Petitioner, your lord. Petitioner.
K. Panda. Apollo 9 on behalf of Sunil Panda. Is it your matter? Sure.
Yes, on behalf of Sunil Kumar Panda, man.
Rajiv Lochan Patnaik on behalf of Sunil Kumar Panda for the petitioner. A hybrid.
My lord,
Also, Mr. Patnaik is present in VC and addresses arguments. Yes,
My lord, in this case, I have challenged the order dated 15/1/2024, my lord, where the George Family Court granted maintenance rupees 6,500 for the opposite party number 1 and 4,000 for the opposite party number 2. And,
Yes.
And subsequently, my lord, another order has been passed in the said judgment that monthly maintenance rupees 7,600 per month for the petition opposite party number 1 and rupees 4,600 for the opposite party number 2, my lord. In this
Right.
case, my humble submission is that, my lord, the present petitioner working as an assistant teacher who is getting salary.
It cannot be looked into by this court in revision. It is a matter of evidence. Issue you can challenge very well. You have to secure the decree here. You have to show how much. One thing is that how much you have paid as interim maintenance, all these things.
My lord, I have already paid, my lord, 1,12,000.
So file that detailed affidavit, date of order, when you have paid. Otherwise, this fishing expedition, what would happen if I issue notice, then whether it will be paid? I am not entering into that fishing expedition.
Yes, sir.
Deepak Gusra's usual language, non-application of mind by High Court in Samima Faruqi. So those kind of comments I will not invite.
Okay, sorry.
If you are not paying, secure the decree here, deposit the money here, then let us see.
My lord, in this case, already total he paid rupees 1,12,000 out of area maintenance.
Sir, that is not a part of your speech or my understanding. That is a part of the record affidavit.
Yes, I will file affidavit.
So you do that.
Yes, your lordship. May I pray one thing, your lordship?
Because you see, plea to be bargained, but a decree cannot be bargained before the revisional court.
No,
Doesn't have any jurisdiction.
I'm not bargaining, my lord.
Now, if you are inviting the court for reappraisal of evidence, as you are saying, assistant teacher, all these things. So he has to show to the court, he should have shown to the court, trial court, that this is my source of income, I cannot pay. Then you have made up a case that though I have showed the court, my income is X, I'm sorry, 100, but the court has directed to pay 110 or 90, which is not reasonable. So that you have to show, not re-argue the matter. I will start taking evidence, looking at different documents.
No, that plea has been taken in the landed court below, your lordship. That is reflected in the judgment also. That is the finding of the landed
Page
court.
20. Look at page 20. What you have adduced?
My lord, the opposition.
Which is your evidence or affidavit or exhibit showing that what is your salary?
That I have not exhibited any document.
So you have to understand, because if suppose I start dictating your order, what you have submitted is completely contrary to the record.
No, that is in the judgment.
Why should I check the list of exhibits and statements?
Yes,
See,
sir. I will.
your contention, Mr. Patnaik, is that the learned trial court did not consider what you have adduced. Now, when I show you what you have adduced, you say that I have not adduced. That should not happen.
One thing I will.
Be clear in your approach that you are officer of a court. What you will say, that will be exactly reflected without any cross verification.
Yes, sir. Yes, sir.
Well, because the person who is approaching this court must understand you are officer of the court. He has to treat you with respect.
Yes, sir.
If he has not done that, then he may file there whatever modification in 125(3)(4), but not revision by saying something, by narrating a story. Anyway, leave it there.
My lord.
Representation. The petitioner husband is before this court challenging the judgment dated 15/1/2026 passed by the Learned Judge Family Court, Borgad, in C number 46 of 2022. The petition was filed by a wife in the marriage, and the minor child is at about 11 years. Then is at about 11 years. Seeking monthly maintenance of rupees 15,000 for both mother and child. to be paid by the husband dash father. The CRLMC, the consider CRMC account, whatever. That C.M.C, CRL.M.C was favored. However, directing monthly maintenance of rupees 6,500 to the wife in the marriage and rupees 4,000 to the minor child from 22/7/2022 till 30/11/2025. Stop. It was further directed. The monthly maintenance to be paid is rupees 7,600 and 4,600 from 1/12/2025 onwards. अपरे total amount का calculate कर दे till date.
Total amount, my lord,
So
4,20,000.
apparently the total amount due from 22/7/2022 till 30/11/2025.
That is 4,20,000.
तो month संगे amount का गुणी देगा. And from 1/12/25 till
1/3/2026, your lords.
1/3/2026.
That is 36,600 rupees.
In view by the Honorable Apex Court in the judgment Rajneesh versus Neha, citation table, have held that the money awarded to the wife as maintenance is in the nature of a money decree. Since the petitioner is seeking to challenge the money decree, learned counsel for the petitioner has adjournment to obtain instruction. The petitioner to secure the said decree stuff. The learned counsel shall also file the details of the payments already made pursuant to the orders passed in the said proceeding or any other proceeding. List in the week commencing. Kebe chahuchanti?
Next week, your lords.
Next week as per execution file is
Yes, my lord. Execution has been filed. That is execution miss case number 15 of 2026.
Best way is that you satisfy the decree.
Yes, your lords.
You deposited there some amount.
Yes, I have already deposited, my lord, 1,12,000 rupees. That has been mentioned by the opposite party, number 1, in the same suit.
Sort thing.
Obligers.
Yes, please. Next.
Obligers.
Yes, please.
Item 10.
Petitioner wife filed an application.
Mohammed Irfan.
Riaz.
You are Riaz. Again, there is confusion. Mr. Mohammed Riaz for the petitioner. Yes, please.
Transfer application filed by the wife seeking a transfer from Hon'Ble to Bhadrak.
How many cases he has filed against the husband?
On 2 cases before the
Two cases she has filed.
She has filed.
498A?
No, 490 DP and 120 CRPC.
You take notice, but I don't find any provision in law where, because 24 says, looking at the convenience of the parties. So how can you argue that convenience of the wife?
Because
so you have to cite some decision.
Yes.
That's why 24 has been interpreted that only one person to be looked at. The other person, I'll turn my head the other way. You take your seat, I'll dictate the order. The petitioner wife is before this court seeking transfer of the CP number 261 of 2025 pending before the Court of the Learned Judge Family Court Rourkela to the Court of the Learned Judge Family Court Bhadrak. The CP has been filed by the husband in the marriage under paragraph 281 of Mullah's Principle of Mohammedan Law. Read with Section 7 of the Family Courts Act. She stays at Bhadrak with her parents.
No.
It is submitted by the learned counsel for the petitioner that the petitioner, after her marriage has gone into rough weather, now stays with her parents at Bhadrak. Bhadrak na Basudevpur?
Bhadrak district.
District Bhadrak, at Basudevpur in the district of Bhadrak na Bhadrak?
Bhadrak original Basudevpur was the parent house. She was residing in her uncle house.
She stays with her parents at who reside at Basudevpur in the district of Bhadrak. Para. Issue notice along with this order. There is a minor daughter also.
Minor daughter, 6 months.
She stays with the mother.
He was mother.
The minor daughter from the wedlock also stays with, not stays with, is in the custody of the mother. Stop. Happen issue notice along with this order. Stop. Para. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days.
5 months.
Within 5 working days. List after SR. Liberty to mention. IA 38 of 2026. Have learned counsel for the petitioner. He reiterates his submissions as noted above. Issue notice to the opposite party as above, accept one set of process fee as well as postal requisites. Next date of posting in CP. Date kebe achi?
CP already passed. 27 February.
As an interim measure, it is directed that the learned judge, Family Court Rourkela, shall adjourn the matter, adjourn the CP number
261 of
261 of 2026.
25.
अपन एटा जो तापर स्टार मार देले देखा जाउनी आगे CP number 25 of CP number केते कहले 261 of 2025 beyond sorry beyond 13/4/2026 to a date as would be convenient to the learned court in season of the matter upon a prayer being made therefore. On a returnable date fixed for the to 6th April. List in the week commencing 3rd April. Yes.
11. Petitioner is the
Subudhi for the petitioner. Yes, Mr. Subudhi.
My lord, petitioner is the wife. Now she is residing with her maternal uncle at Fulbani searching for a job.
The law has not evolved like that. Wherever the wife will stay and search for a job, the CP has to be transferred.
My lord, CP.
The objective of expeditious disposal of the matrimonial causes are getting completely, entangled in this kind of litigation.
No, my lord, CP is filed at a family court, Barampur.
Obviously, sir. Section 19 of Family, the Hindu Marriage Act is very specific. Family Courts Act is very specific. 24 is also very specific. Looking at the convenience of the parties. Upon that, read the convenience of the wife in the marriage. That what is not there. Section 19 the wife job khojibe seti hobo.
No, seti paini.
Then, sir, you must understand that our discussion should be legally nuanced.
Her parents are unable to maintain her day-to-day life expenses.
Sir, where is that provision in the law?
She is residing with her
section. I understand. Who provision the parents I don't find it anything. Section 9 of CPC says that all suits are to be inserted. Mandate of Supreme Court, High Court is that we are pouncing upon the judges that you dispose of. But much disposal purvuru upon transfer file kale 5,000 pending rahila. And now after invention of ICT, I mean intervention of ICT, anywhere you can appear, anywhere you can stay. That is why in many of the cases Supreme Court has directed not transport interstate.
No.
From Kashmir to suppose the wife is husband is employed at Kanyakumari, wife stays in Kashmir. The Supreme Court says that you join in ICT, video conferencing, virtual deposition, virtual court, everything. So do you avail that? So today or you want to obtain instruction. I am not in a hurry to pass an order to score disposal, but not that. But you must understand what order I will pass must at least should consider the provision. There is no such provision. आज order कर ना next week ना केबे चाहूँ
Next week instruction में
आपनकर problem होची जे once the notice is issued, the TRPC is filed here before conciliation.
No, my lord. No.
And obviously the notice is not. Suppose I am entertaining it, can I take it up and dispose of? I cannot.
My lord,
That is also another problem.
my lord, she had appeared on 4/2/2026 through her counsel before the law and
How can you ignore a lawyer in a proceeding? Or a lawyer at Barampur or lawyer at Fulbani?
So full body
Her lawyer will be there, she will appear from wherever she stays.
distance is 165.
It has to be, sir. It has to be. That is why I gave you the example of Supreme Court deciding matters east and west. I think Gujarat and Kolkata, I have read it. Does the Supreme Court transfer? Why? Because the problem is that convenience of parties, it says. It is not convenience of a particular party, individual. And if that is the law, some case law, that wherever the wife wants, then cite it so that it will be easier for me. Yes. But
She had no independent source of income.
sir, I must then have to record that for persons who are do not have independent source of income.
I will take instruction.
For them, Fulba is convenient. Because that logic I have to reflect in my order or not. How many cases he has filed against the husband?
No, petitioner has not filed any 125 maintenance also she has not filed.
Then she should immediately file section 24 before the learned judge Fulbani court. Instead of spending time here in section 24 CPC for transfer. That she has to consult the lawyer because they are though not admitted but amicus curiae they are engaged. The learned counsel for the petitioner was heard at some length. It is submitted that the petitioner wife stays at Barampur and she wants the matter to be transferred to Barampur, the district of Banjar. The CP has been initiated before the learned judge family court.
Barampur Ganjam.
It is कितने number item है?
316 11.
गंजापुर फुलबाणी चाहूँगी
ଆଜ୍ଞା
ତାହେଲେ ସେଇଟା ନିଶ୍ଚୟ ଫୁଲବାଣୀ କରିଦେବେ ଫୁଲବାଣୀ ଷ୍ଟେଜ୍ ଆଟ୍ ଫୁଲବାଣୀ ସବୁ ଠିକ ଅଛି କଣ ସେକ୍ସନ 19 ରେ this is not maintainable at ଫୁଲବାଣୀ we follow for 19 is very clear it's not maintainable at फुलबाणी just family court Barampur at Ganjam. Para. The learned counsel for the petitioner has adjournment to obtain instruction. In view of the provisions contained in section 19 of the Hindu Marriage Act, section 9 of the CPC, as well as section 9 of the CPC. That no ତାପରେ ସେ ଛାଡି ଦିଅନ୍ତୁ ଆପଣ ତ କେବେ ଚାହୁଁଛନ୍ତି
next case
ନିଶ୍ଚିତ 16/3/2024 yes
May I please your lordship? Lordship, the petitioner filing this case for seeking transfer the proceeding CPB case number 559/2025 under section 13(1) of Hindu Marriage Act, which is pending before the family judge
she
Baleshwar.
is a doctor
My lord.
she will not engage a lawyer the same logic section 19 section 9 CPC nowhere it says that
She is
The place has to be the place of residence of the wife or where he is searching for job.
My lord, kindly glance page number 6 of my petition.
For glancing the page is answer law.
The
Because
petition.
section 19, this court has to follow.
My lord.
Section 19 clear.
My lord.
So the dominus litis has to choose the place of litigation. Now instead of let us assume
My lord.
it is filed at a place which the court doesn't have jurisdiction according to 19. You want to register the first point, you will take that. You do not have jurisdiction, territorial jurisdiction. So the suit should be dismissed.
My lord.
Then that is another thing. But at this stage, section 24, then section 24 says that convenience of the parties. Then how the only convenience of one party is predominant?
Apex court gave priority of wife convenience. Honorable court decided in the case of Anita Pandey versus Aravinda Shukla.
Can you read the paragraph? What is the facts of that case?
I have only cited the
Don't never read cases like that.
2016 one.
You see that if you have a case that the Supreme Court says that if the wife decides, then you cite that and please read that. Upon ନିଜେ ବି ପଢି ଯାଆନ୍ତି କହୁଛନ୍ତି.
My lord, I have ରଖିଛି but issue notice and the petitioner wants for reunion, my lord. She does not.
ସେଇଟା ଆପଣଙ୍କର ସେଇଥିପାଇଁ ଆପଣ ବୁଝିପାରୁଛନ୍ତି you are frustrating that process.
My lord.
I hope you understand the litigation method in Hindu Marriage Act and Family Courts Act.
My lord.
By this method, you are not allowing the court for reconciliation and reunion. The mandate of the statute is that after issuance of notice, the court will conciliate. So now the High Court intervenes, stays the proceeding, or transfer to another case. This is a case pending since
2025.
Now suppose it is transferred as 26. Wherever it goes. If you do not listen, then you will not understand. The priority also decreases. Already suppose you want it where? Bhubaneswar or Cuttack? Cuttack court is overburdened. It cannot be prioritized. So at the stage of issuance of notice when conciliation is about to happen, you are just intervening, inviting this court, which is not, that is how the statute is very clear. And if you are ready, then you place it on the next day. Miss Pranani, you are Miss Dasma Patra. Miss Pranani Dasma Patra for the petitioner. The petitioner, the Lord Counsel for the petitioner was had at some length. The petitioner wife in the marriage has approached this court seeking in a section 24 application before High Court. Can conciliation take place? Answer is no. But since we are a superior court, we can do that. They are family court counselors. They are employed for that purpose. When the notice is issued, the first duty, the court has to record. Court has to record and send it for conciliation.
In this
that procedure I cannot do here.
My lord, in this case, the petitioner wife, she wants for reunion and not file any case at any forum. And also,
Ms. Mahapatra always try to follow what court is saying. You are speaking English, I am speaking English.
My lord.
The effort of the petitioner for union by conciliation is frustrated by this litigation.
The petitioner.
You are frustrating that process. Again, it's adversarial. I will have to issue notice. He will appear here. He may say 20 things. So at this stage, when the court issues notice, the provision is there for conciliation. That is being frustrated by you by approaching the court, but the wife herself is chopping off the branch where she sits. Transfer of the yes. Transfer of the CP number 559 of 2025 filed by the opposite party husband in the marriage. Stop. The said CP is pending before the learned judge family court Balasore.
Yesterday, the case was posted.
He is working as Balasore.
The opposite party.
You are not listening, madam. Develop a habit of listening so that it becomes interactive. This can't be a monologue. Upon the petitioner's address statement is very clear. She is working as a doctor in Balasore. So now 24 says that convenience of the parties. She wants to litigate. He wants to litigate.
Petitioner working at Sundargarh NTPC Gully, Sundargarh.
It is submitted by the Lord Counsel for the petitioner that in the decision of
In the decision of Anita Swatnaik versus Aravinda Shukla.
either say copy
Paragraph 6, page number 6.
judgment ଆଣି ନାହାନ୍ତି
Judgment.
The Royal Counsel for the petitioner relies on the decision rendered by the Honorable Apex Court. Anita Patnaik versus Aravinda Shukla. Colon 2016 into bracket 1 OLR 824. To submit that for the matrimonial case, the convenience of the wife has to be looked into, and accordingly it has to be transferred to the court of jurisdiction where the wife wants. Stop. It is submitted that though she has mentioned the citation, it is submitted by the Lord Counsel that though she has not mentioned, she has mentioned the citation, but she has not gone through the same decision. And adjournment may be granted. ଦେଖିବେ କେବେ ଚାହୁଁଛନ୍ତି? When do you want?
April 6 ରେ ଅଛି ବାଲେଶ୍ୱରରେ କାଲି ଥିଲା।
ଶୁଣନ୍ତୁ ଆପଣ ଯୋଉଟା ଆଭଏଡ୍ କରିବା ପାଇଁ ଏଠି ଟ୍ରାନ୍ସଫର ଫାଇଲ କରୁଛନ୍ତି, that is I will not be a party to that.
No, my lord, the petitioner is
See,
working.
the husband is working in Baleshwar.
Husband is working as Keonjhar.
Baleshwar is near to Keonjhar, it is his residence. April ରେ ଅଛି।
My lord,
ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି ଡେଟ୍? ଏପ୍ରିଲ ପରେ ନା ଏପ୍ରିଲ ପୂର୍ବରୁ କିନ୍ତୁ କହୁନାହାନ୍ତି।
April ପୂର୍ବରୁ।
You are not telling me.
No.
Telling the court, not telling the court. List in the week commencing 16 na 23 23
Yes.
But it's good that you have made some effort, but you must read the judgment to know the facts and what is there, what the court has decided.
Right.
You have given a citation without reading it. That should not happen.
ବହୁତ ଅଛି ତ
No.
marking କରିବି।
Now the major challenge is in after the advent of this large language models, wrong decisions are being cited. It is not mistake of the person actually, it is the mistake of the software. Some case somewhere he has read, he cites it. So you have to check it physically. Yes, next.
Item 13, I'm in VC, my lord. This is a case with regard to the custody of a minor child of around 4 years old. The child is at present staying with the father at Baleshwar, and the wife / mother is staying at somewhere in Fulbani. So she has filed an application for custody of the child under section 25 of the Guardians and Wards Act at Fulbani Family Court. So now we received the notice, and on receiving the notice, we have gone and filed an application on the ground of jurisdiction saying that the court of family court at Fulbani.
I have already heard this and order dated 11/2/2026 is there.
Yeah, I'm coming to that. Now I have come up with a citation of our own High Court. My associate is there, so you'll just pass it on. On the similar facts and circumstances, the division bench of our High Court in 2014 has held that the court can initially take that point of jurisdiction into account.
Trial court or this court?
Our own High Court, my lord. No, High Court has said that trial court can take this point of jurisdiction.
So you raised that?
Yes, I have already raised.
Where is the order passed by the trial court?
Yes, I'm coming to that.
Contention.
Yes, I'm just on page 13, my lord.
If this court starts, if the division bench says that this court has to take that note, then I have to defend it.
No. The division
trial court has to. Yes, of course, that's the point. Trial court has to consider that. Yes,
but in my case, what has happened, dear lords, may kindly come to page 13, 1-3. The order dated 27/1/2026.
Yes.
The case record is posted today for hearing on petition dated 2/1/2026, heard from both sides on the point of jurisdiction. This petition will be disposed of with a view that this issue will be taken for determination at the time of final decision. So this is what the trial court has said. My point is that this should have been initially decided by virtue of the decision of our own High Court, my lord.
That which paragraph?
Yes, my lord. Yes, my lord. Your Lordship, kindly come to 1 second. Paragraph 13, 1(3). It is plain in the context of clause 2 of section 19 of the Act that the word resides.
Kindly just, I could not get the paragraph.
1(3), my lord, 13, 1(3).
No, 1(3) of which decision you are reading?
No, this is the judgment I am citing, my lord.
Dilip Kumar Behra.
Yes, my lord. Dilip Kumar Behra, paragraph 13.
30 or 1(3)?
1(3).
It reads the admitted facts of the marriage between the appellant.
No, ma'am. No. I am just starting from paragraph 13. It starts with, it is plain in the context of clause 2 of section 19.
No, it does not read so. It reads the admitted facts are that the marriage between the appellants. Dilip Kumar Behra, Division Bench.
Versus Pushpanjali Behra.
2015 SEC Online, Odisha 169.
Yes, my lord. The same thing is there. I'm reading paragraph 13.
You are reading SEC print or other print?
No, this is the SEC print only, my lord. My associate has just taken the same copy with her.
13 doesn't match?
No. So I'm sorry, my lord. What we can do, your lords may kindly come to paragraph 16, subpara 30. We can start from paragraph 16, and that deals with paragraph 13 of a reported judgment. 1(6). Then we come in that paragraph 16, we come to paragraph 13. Next page. Lordship has got it?
Yes.
It is plain in the context of clause 2 of section 19 of the Act that the word resides must mean the actual place of residence and not a legal constructive residence. It certainly does not connote the place of origin. The word resides.
That is a typographical mistake.
No, I'm just coming to the last 3 lines.
So that paragraph is not 13, that is 17. Wrong type does 13.
Anyway, that is the paragraph I'm relying upon. The word resides is a flexible.
Two 13 paragraphs, one before, after 12, and one after 16.
So this is actually after 12. After 12.
Yes. Not 12. Not 12, it is after 16.
There is some confusion. It is in the paragraph 16.
Actually, what has happened? The paragraph 12 is quoted in paragraph 16. The next paragraph is typed as 13.
Exactly. Then it should be 17.
So that is how there are 2 13 paragraphs. You are looking one and I am looking at another. Yes. It is plain in the context.
Yes. It is plain in the context of clause 2 of section 19 of the Act that the word resides must mean the actual place of residence and not a legal or constructive residence.
Again, Mr. Acharya, you are saying that the order is wrong because the court did not decide.
Correct. I'm coming to that.
Kindly appreciate this. Your contention is that this division bench has decided, it has to be decided fast, not the way the court has decided. Heavily judge has decided. So straight away go to that line.
No, I'm coming to the 4th line from that paragraph because that is relevant for my case. The word resides is a flexible one and has many shades of meaning, but it must take its color and content from the context in which it appears and cannot be read in isolation. Now, this is important. It follows that it was the actual residence of the appellant at the commencement of the proceedings. This is important. That had to be considered for determining whether the district judge Almora had the jurisdiction. Now here what has happened? Admittedly the child is with me.
You are not reading further. You are adding your comments. Just read further.
That being so, the High Court was clearly in error in upholding the finding of the learned district judge that he had jurisdiction to entertain and try the petition for annual.
So this judgment is against you.
No. What I'm trying to say.
This is a case kindly appreciate this. This is a case what is cited by the division bench of this court. They cite Jagdish Chandra.
Right.
Then Jivanti Pandey.
Right.
So Jivanti Pandey, what has happened? The district judge held that answer. The district judge, family judge Almora.
Right.
Answer that the Almora has jurisdiction.
Correct.
The challenge is section 19, which I am telling you that if a challenge in 19, that the district judge has to answer.
Correct.
That decision of the district judge Almora was challenged before the High Court.
Correct.
The judge High Court, he says that the district judge is correct.
Correct.
Now they go to Supreme Court. Supreme Court says that wrongly decided. So now, this decision doesn't help you because the High Court district judge has said, I will decide the place of jurisdiction.
Now I'll just change my argument for a moment.
So now, Mr. Acharya, let me put it differently.
Yes.
If the lauded judge, family court, Baleshwar, Kandhamal. If the lauded judge, family court, Kandhamal has decided the territorial jurisdiction, answered like Almora, yes, you are challenging it. Now he says, I will decide. But that stage you are challenging, you are saying, no, before you cannot keep it like that, you have to decide first, then, because usually section 19 is a mixed question of fact and law, not usually, always. So you have to adduce evidence. If you are challenging the jurisdiction of Kandhamala court,
right,
territorial jurisdiction, then it has to be a question of fact first.
Right.
Because it is residence and other recommendations are there in the section. It will decide against you. You can challenge it.
Yes. Now.
So now you want that before the court adverts into evidence, any kind of evidence, he has to decide. That is the problem for the court. Because then what would happen? Court has to take evidence twice. First to determine the jurisdiction, second to determine the issues involved. That becomes a very cumbersome and in fact conflicting also. Because then your witness for proving this territorial jurisdiction, their witness for proving territorial jurisdiction will be examined. That issue will be answered. But with the same effort, the entire case can be decided. That is the reason. Usually, all the issues are answered together after the evidence is recorded. And this is not a case where, like Almora, like this, Jivanti Pandey, like Jivanti.
Now let me put the facts of this particular case which I am relying upon, my lord.
Please don't place me the facts. You must tell me which order you are challenging.
The order I am challenging is that
has the Kandhamala court decided the jurisdiction?
No, not yet.
That's the problem. I cannot apply Jivanti Pandey and apply Dilip Behra.
No, let me just tell the facts of Dilip Behra case for a moment, my lord. Just give me 1 minute.
Mister, I have been requesting you from the beginning. And that is how, when I realized that you are addressing something else, I interrupted you. If Dilip Behra says that the judge family court has to decide the jurisdiction, territorial jurisdiction first under section 19, straight away bring that line to me so that I can understand. You took me to Jivanti Pandey. Jivanti Pandey is completely different. Rather, Jivanti Pandey is against you. Because if the court says that the court has to decide, when it has decided, Jivanti Pandey is also not clear.
Correct.
Yes.
Now let me just tell the facts of Dilip Behra case for a moment, my lord.
Sir, we are discussing. If you are saying that the court has to decide, you take time. If the family judge has a duty to decide territorial jurisdiction, that is the ratio of Dilip Behra, then straight away, right now you go to that line where the court said so.
Then we come to paragraph 18 because it is very important to know the facts of Dilip Behra case for a moment, my lord.
Sir, even if I know the entire facts, that will not help me unless I see Dilip Behra, the direction of the division bench, where it has observation, that is the territorial jurisdiction has to be decided. Okay. That you show.
Let us start from paragraph 18, my lord, of the same judgment which I was relying upon. Last but two paragraphs.
I am already there.
Yes. In view of the aforesaid decisions of various courts, when the facts of the present appeal are expedited and scanned, it becomes unambiguous that Nilesh was residing with his mother since last more than 3 years.
Well, against you, Mr. you are not getting. You are citing a decision which supports my understanding that court will decide at the appropriate time, not at the beginning.
But here the division, but here
So because you are very, I mean, you have to also, you are very fairly said, no determination, the court has not decided the territorial jurisdiction. But again, you are reading 18, the court has decided the territorial jurisdiction.
no, here what has happened in Dilip Behera's case.
It is like this. It is like this. You are raising a issue of territorial jurisdiction. Court is yet to answer that.
Right.
So says that I will decide. Now you come to High Court saying that no, you ask the court to decide it now. So that direction I want from Dilip Behera. Guidance.
That is why I have to read paragraph 18, then come to paragraph 19.
Instead of reading the paragraph straight out the line, you should have. I have completed reading 18. That is what I am telling.
Then I'll read paragraph 19 because here what has happened.
It says court has to decide before deciding everything else. Because that's the point. Because that will be the reasoning in order.
Because in Dilip case, at the very first instance only, the family court at Rourkela said, I have no jurisdiction because the child is staying at Phulbani. And against that order, the matter came before this honorable court.
There is no instant answer to that. The problem is that if the court has, here the order is 27-1-26 is very clear.
Right.
It says that I will decide.
But in
has to decide it now.
But in
for that you are citing data. So para 18 doesn't help you because para 18 doesn't say so.
No, because in
Dilip doesn't say so.
In Dilip Behera case, at the very first date itself, the family court at Rourkela said, I have no jurisdiction to entertain this application under section 25.
Problem. That's the problem. If the court has passed an order in Dilip Behera, that is against you.
No, it's not
Dilip Behera. You are absolutely saying that in Dilip Behera case, the court at Rourkela has held that I don't have jurisdiction. That is challenged.
Exactly. Right.
The court has not held that. I have been for the last 15 minutes or 20 minutes, I'm asking you, please show me the order where the court has held that I do not have jurisdiction or I have jurisdiction.
Exactly. Then I'll just come to that 1 second.
That order is not there.
One second. Paragraph 14.
Then you cited the wrong order also.
Then I'll come to paragraph 4.
You are saying order number 15?
Paragraph 4 for a moment, my lord.
Which paragraph 4?
Of the judgment. Of the judgment I'm relying upon.
No. Like Dilip Rourkela that he doesn't have jurisdiction.
That he has held, that it has been observed in paragraph 4 of this citation I'm relying upon.
You read actually because this way, because what I'm telling you, you are not most likely you are not following also. I'm saying to apply Dilip Behera, you showed me the court has decided the jurisdiction. Again, you are taking it back to Dilip Behera case. I'm asking you the family judge where it has decided the jurisdiction.
At paragraph 4, my lord, that's what I'm trying to say.
Sir, Acharya, you have already answered that he's yet to decide. He has not decided, he's yet to decide that.
As far as the Dilip Behera case
Dilip Behera, Dilip Behera is a case where after the court, family court Rourkela has decided that I do not have jurisdiction, that is challenged.
That decision was taken right at the very first day without issuing notice also.
Whatever, sir, Dilip Behera, we are not, and the High Court has said, Dilip, the determination regarding jurisdiction is not correct.
The High Court has said that the Dilip Behera decision is correct as far as the family court Rourkela is concerned. That's what I'm trying to say, because in paragraph 4, the High Court has quoted the observations of the family court Rourkela.
Either I'll close up because I have got your point. There's nothing. Because I tried, I thought that there is a direction in Dilip Behera that the court has to decide it. But
no, because in the case of Dilip Behera, the family court at the very first date.
Which order you are kindly again you have to start from the beginning. Which order you are impugning in this court?
The order I'm challenging is
order number 15.
Yes, order dated order number 11, my lord. Not 11, not 15.
Kindly read the order again.
Yes. The case record is posted today for hearing on petition dated 2/1/26. Heard from both sides on the point of jurisdiction. This petition will be disposed of with a view that this issue will be taken for determination at the time of final decision. What I'm trying to say, my simple line of argument is that my application should have been decided at the very first instance.
That is how the problem is, that you are following upon Dilip Behera to buttress your submission. Dilip Behera is just contrary. Dilip Behera says the Rourkela court has decided it doesn't have jurisdiction.
Because
you read para 18 again. You read para 18 again.
No. Before I read para 18, para 4 is relevant for this purpose.
You read as many paragraphs, though there are some wrong numbering.
Yes, please. I would like to read paragraph 4 for a moment.
You cited paragraph 13. Paragraph 13 of the quoted decision.
Yes. Because my only contention is
Judge at Almoda, Jivanti Pandey, the court at Almoda said that I have jurisdiction. High Court confirmed jurisdiction. Supreme Court said no. Court at Almoda doesn't have jurisdiction. In Delhi Bera, the court at Almoda said that I have jurisdiction. Now
in Delhi Bera case,
do not have jurisdiction.
Does not have
jurisdiction. The court at Rourkela said that I do not have jurisdiction.
And you go to Berhampur. That is what exactly we are trying to say. Because court did not wait for the trial to take place on the very first day of case.
Sir, I cannot add those lines to Dilip Kumar Behra case. The court has to say
that is the law laid out by the division bench.
If there is a division bench where it has said, kindly find out. There you are struggling.
Paragraph 19, my lord. Because ultimately it has upheld the decision of the family court.
Where the division bench has held that this order, because the problem is Dilip Behra is against you.
It's not against
Dilip Behra is completely against you because Dilip Behra has treated a situation where the court at Rourkela refused to entertain the petition, saying that I do not have jurisdiction. Here I am telling you by which order the court has directed I have or I do not have. Court has not said that. I cannot put those lines in my order when the court has not said.
Because paragraph 19 court has confirmed the order of the family court. It says because the child is at Berhampur, Rourkela court doesn't have. The same thing applies to me. Because the child is with me at Baleswar, not at Fulbani.
That cannot be the ratio.
That is the ratio laid down by this court. This is the law I can understand. This is the law that I can understand at least.
It is not the ratio.
No, this is my view, my lord. I may be wrong, but this is the law I understood.
You are struggling to get the facts even. Your view, greatest of respect, I have been telling you, sir, by which order that jurisdiction has been allowed or refused, and by which order the court has said that.
This is only the impugned order is just
if you apply Queen versus Latin, Lord Halsbury, it says that the judgment cannot be read like the statute. You are implicating so many things. You are reading, you see the clear case in Delhi Behra is that Rourkela court said that I do not have jurisdiction.
When my point,
the court at Almoda says that I have jurisdiction. Now this court has not said, I will write a judgment that because the court has said that it has jurisdiction or not jurisdiction.
What I'm trying to say is something else, my lord. My point.
Actually, I cannot deviate from the whatever is there in the case. That I cannot change.
I'm not saying that. What I'm trying to say, as far as my factual case is concerned, the child is with me at Baleswar, studying in Baleswar school.
Anyway, I've already spent time. So you want adjournment or what?
If your lordship doesn't want, naturally I have to take an adjournment because this is the law I have understood.
Then please be present at 2. Record your submissions and I'll pass to record.
No, let it be adjourned. Let it come next week.
By spending half an hour, I cannot leave that. Your permissions.
Then I'll come. Then I'll come.
Because of the recess.
I'll come physically at 2 p.m.
Yes, rest of the matters are recessed.
May I just be permitted another 5 minutes at least?
No, because we are doing actually, when you started submitting, I was happy that I will conclude it.
Right.
Because you made a very sharp point that the court has to decide the issue of jurisdiction in context of section 19 here.
In section 9.
Section 9 here of section 9 of Family Court Act.
Guardians and Awards.
Guardians and Awards Act, jurisdiction part. But as you took me through the decisions, the decisions are all where both Supreme Court as well as High Court.
Yeah.
After the court has decided the point of jurisdiction, territorial jurisdiction, of course, territorial jurisdiction. It's not a case of peculiar jurisdiction, it's a case of territorial jurisdiction.
Exactly.
Then one of the party has challenged it. In case of Almoda, the party challenged it before High Court.
Right.
High Court agreed with the district court or the family judge. Then Supreme Court said, no, both family court and High Court are wrong. That's not the scenario here. Other matter, Dilip Behra, Division Bench of our High Court. The Rourkela Court decided against the party.
Yes, that is where I want to pause for a moment.
What you are saying, that since on the first day,
Exactly.
the Rourkela Court has decided the jurisdiction, that is the precedence.
Right, right.
Which completely against Queen versus Latham, because the High Court has to say that.
Correct.
So factually. So maybe some other day, at least we had some purposeful, but since there is constant of time, so let us not continue it today.
I'm okay with that.
Because on the last occasion you said that the boy was not interviewed.
Yes, I still say.
So this is a case of interim order or it's a final order?
No, he has filed an application by
During the guardianship petition,
Yeah, we have filed this
the
application.
vegetation and contact rights
Both are
was granted. So that is how the last day we discussed that whether court can refuse vegetation and contact right to either mother or father. That was the point.
was the case of another case I was appearing, not in this case. Not in this case. Here actually.
So this point actually in both the cases,
Yes.
it is very stark actually. Almoda and case of Odisha High Court.
Correct.
So that is how Justice Prasad has relied on the decision of discussed after there is a determination by the court either way.
Exactly.
But your point is that since paragraph 18, the Rourkela Court.
Now for a moment I'm forgetting all the paragraphs. I'm just telling only one line of the fact of that Rourkela case. Rourkela case, the husband filed a petition for guardianship before the family court Rourkela. By that time, the child, who is about 4 years or 5 years, he was with the mother at Berhampur. On the very first day, the suit itself was not admitted on the ground, court saying, I have no jurisdiction. And
That I have been telling you.
Yeah. And against that order,
Rather, that has been my effort to tell you that Rourkela was a determination of the territorial jurisdiction
at the very first
against
day.
as they or when the court had taken a decision.
Yes, yes.
So that is how you have read and reread the informed order here,
Exactly.
which says I will decide.
Right. But
Which says I will decide. Now, as we are discussing, I said
Exactly.
since applying section of CPC, section 9 or section 19 of Hindu Marriage Act,
Exactly.
which confers jurisdiction.
Exactly.
It is a question of fact actually.
Definitely.
Because it talks about residence of the parties.
Correct.
So it will be a mixed question of fact and law. Primarily a question of fact actually.
Exactly.
The reason being if it is proved, so one party may agree, the parties may challenge also. The respondent may, the opposite party may challenge that you do not have jurisdiction.
Exactly.
Now when the court will decide, in your case the court said, okay, I mark that point, but I will decide.
But
So now I start applying both Dilip Behra
yes.
and Almoda. That becomes a problem because the court is yet to decide.
Your Lordship, we can at best can say this, I mean, subject to corrections. Because the family court has said, okay, I'll decide it at the final stage. So what can be done just to avoid or save the court's time? Let that point be first decided once the written statement is filed. Because now what happens now, supposing...
Mr. Acharya is that if the court says, that will save court time. Suppose I give
that is what I'm trying to say.
I am issuing a direction to waste court's time. Same set of evidence, same set of pleadings, the court has to determine the territorial jurisdiction.
But
because both the parties without being in dark,
exactly,
can it be decided that where you are staying? You will ask, obviously, you will ask that to dislodge the jurisdiction. They will argue that we are staying here. and whatever, section 19 or 9, they will apply. So that is one of the reasons that framing of issues should be at one go, and examination, suppose at the stage of examination, these questions are asked, and apart from other merits, court has to decide.
Exactly. But
So
again,
this way, if I make it do direct, that you first, because now can I do it without adducing of evidence?
no, let a preliminary issue be framed as far as the
Preliminary
jurisdiction.
issue which touches upon the
Heart of the
case, it has to be evidence. It has a serious consequence as far as one party is concerned.
But I was strongly relying on this Dilip Behra case because here what has happened the very first instance only.
I have been simple one line. In fact, I was thinking that is the ratio of the court. I mean, ratio decided by the division bench. Court has to decide. But that is not there.
No, but ultimately what the division bench has said.
What
What
has happened
Dilip
is
Behra's
that
case.
Dilip Behra, after Rourkela court refused jurisdiction
Exactly.
or rejected jurisdiction, its jurisdiction,
Yes.
then they challenged it in High Court. So that is how the court has cited all those decisions.
No, but ultimately the division bench has said that what the family judge at Rourkela has done, that is correct. He has decided the jurisdiction at the very first instance that because we see paragraph 19.
The issue.
No, issue is something else, but ultimately the bottom line is the same.
I cannot deduct it. The Queen versus Latham is very clear.
But can I play one thing? Let it come another day.
Yes, yes. I was saying that.
If there's any direct judgment, then this is the last.
This kind of problem hearing.
Exactly. I know. I
I
understand.
mean, one senior advocate mentioned he's passed over the matter and he's waiting in the fringe,
I know.
looking at me, what I'm doing.
I know.
So,
Let me see if I can get any direct judgment, but it's really doubtful. But I'll still try.
My lord, I am in VC. I'm
Gautam Kumar Acharya, senior advocate, along with
Sandhya Panda.
Sandhya Panda, and your name, sir?
Santosh Sahu.
So, Santosh Sahu for the petitioner. Other side, T. Asilin.
But they're already entered.
my lord, I am there. My lord, I am there in VC.
Opposite party.
My lord, I am there in VC.
Opposite party, Arun Kumar Acharya Lekhitan. Though the matter is listed for fresh admission, apparently Sri A.K. Acharya and associates have appeared on behalf of the opposite party by filing Wakalatnama. Wakalatnama check kariyo.
My lord, I am there in VC.
Dekho, Wakalatnama apne I would have Wakalatnama lagi region. The senior advocate was heard at length.
My lord, I am there in VC.
Kindly take your seat. I'll take some time to dictate the order.
My lord, am I audible?
It is submitted that.
My lord, am I audible? My lord.
Oh, now, when you are physical, he has become virtual.
No, my lord. What happened, my lord? I am not there in Cuttack, so I am unable to switch on my video. My lord.
In fact, your video is not there. In fact, you are nowhere.
No, I'm not. I'm not. I'm only on.
Others are also looking at the screen.
Just one request to you.
Okay, so I'll mark your presence.
Yes, my lord. And one request, my lord. There is no stay order. They are virtually taking time on this before the Ladakh Judge Family Court because the last date was on 3rd of.
They should take. You see, territorial jurisdiction is an arguable point.
Yes, my lord. That is true. That is true.
Now, after everything, I decide that the court does lack jurisdiction. Then.
No, that is true, my lord.
Of course, you will argue we have discussed that there is no determination, but let us wait.
Yes, ma'am. Yes.
Adjournment. I mean, don't be in a hurry.
No. I'm not saying that, but your lordship may fix
the
date.
adjournment before the trial court. Don't oppose that.
No, I'm not opposing. I just say that later short date be fixed before your lordship.
So this is actually you speaking or somebody else?
No, I'm speaking, my lord. I'm there. Okay. I'm there.
So that is the part of the record also.
Yes.
No, you are not there.
No, I am there, but I am on because I am not there in the robe, so I am not opening my video.
Mr. Acharya, Ladakh Council, Mr. Arun Kumar Acharya, both are Acharyas against each other. So Arun Kumar Acharya, Ladakh Council is present in VC. His video is not visible. He submits that it is his voice.
And I am, since I am outside, my lord, I am not in Cuttack. I am outside.
Wherever you are, sir.
Well, I am in Vizag.
Wherever. Yes. So let us not record those things. Upon the Nahanti picture and Nahanti,
sorry.
He submits that it is his voice and he has some difficulty to switch on the video to show him in the virtual court.
Yes.
Stop. Appearance of Mr. Acharya, Mr. A.K. Acharya for the opposite party is noted. Upon associate with Vizag Sahoo.
No, no, my lord.
Or you have all your Vizag associates.
Sorry, my lord. I've come for a personal visit, my lord.
Senior advocate for the senior advocate was heard at length. To the order dictated the impugned order 27/1/2026. Order number 11.
Yes, madam.
Because there are two orders in 27.
No, 11.
Order number 11, 27/2026, passed by the Learned Judge Family Court, Kandhamar, Fulban in CP number CPO-48/2025. By the said order, the following was directed. Choto order reproduce करते है ना? The case record is posted up to by the defendant. It is submitted by the learned counsel for the learned senior advocate for the petitioner that the learned judge family court should have taken up the issue of jurisdiction, territorial jurisdiction, to entertain the CP first. For the in support of the said contention, he relies on the decision of the division bench of this court in Dilip Kumar Behra versus Pushpanjali Behra, AIR 2015 ORI 200 into bracket SCC online print. SCC online print. He refers to paragraph. He refers to the quoted paragraph 13 of the judgment rendered by the Honorable Supreme Court in Srimati Jivanti Pandey. The देखी लिखी है भूलवाले जीवन versus Kishan Chandra Pandey. AIR 1982 SC 3. এটা আপন নেই দেখি হলা to submit that the said decision to submit that the decision in Jivanti JEEWANTI Jivanti comes to the aid of the petitioner. Stop. He further refers to paragraph 18 of the judgment rendered by the division bench in Dilip Kumar, DILLIP. But perusal of the quoted paragraph 13 of Jivanti in Dilip Kumar indicates that Section 19 of the Hindu Marriage Act was under consideration. Stop. Relying on the said section, the District Court Almora, ALMORA, the District Judge Almora, District Judge Almora, he had jurisdiction to entertain the petition. The said order being challenged before the High Court. The High Court affirmed the order and the party agreed, went to the Supreme Court. The Honorable Supreme Court held that both the District Judge as well as the High Court ordered in deciding that District Judge Almora had jurisdiction. It is submitted by the Lawyer Senior Counsel referring to paragraph 18 that the District Judge Raurkela, the Judge Family Court Raurkela, not District Court. District Court was Almora. The Judge Family Court Raurkela rejected the they held that it had no jurisdiction to entertain an application under Section 25 of the Hindu Marriage Act.
The Guardians and what?
Guardians and Wards Act. Section 9 of the Guardians and Wards Act, 1890. So, apparently, in both the cases at Almora as well as Rourkela, the learned judges had determined and decided the issue of jurisdiction which were challenged before the High Court. Stop. The learned senior counsel has adjournment to advance further arguments. Mr. Acharya and Mr. A.K. Acharya. Mr. A.K. Acharya submits that the matter is getting adjourned before the learned court at now it has Fulbani. In the interest of justice and fair play, the parties shall agree before the learned judge family court Kandhamad for adjourning the matter to a date convenient to the said court. The said learned court. It happened. Yes. List in the week commencing?
Any date after 23rd of March.
30 sir, 6 chari na 30.
Any date is fine.
List in the week commencing 6 chari.
Grateful.
Ismail. 14. Sorry.
Sorangi, Passover matter to be taken up or Monday or Tuesday?
No, sir, I'm acidity so card. Sir, no setre prayer ko nothing to add. What I was saying, I was thinking of producing two documents. Anyway, my lord. Shall I, because appearance date is fixed to 10th before the certificate of.
Sir is appearing in which matter?
7 पे पहुंची सारंग को 14.
अच्छा, sorry, I thought that he
no,
just
sir.
No,
I'm sorry. Sir,
Yes.
7th, sir, what I'm praying, the certificate officer has kept it to 10th. So if your lordship fix it better thereafter also I have no problem, my lord. Only that if I can seek an adjournment, that
the adjournment diyon tu. I mean, you should accommodate a lawyer also. Once I faced this before the court in Qatar, the learned judge refused. Then one of our seniors, I cannot name him, he went. His matter was there. I was present. The way he told the judge and threw the file and asked me that he will argue this matter. So all of a sudden I was not party to him, he is nowhere connected. So that way at least you should consider the plight of a lawyer also. For adjournment answer. 7 Mr. Santanu Kumar Sorangi, senior advocate, along with Mr. Gyanaranjan Naik. The matter was had at some length yesterday and was adjourned for further arguments. The learned counsel, it is submitted by the senior counsel for the petitioner that the matter is posted
10th
by the
certificate officer.
Certificate officer to 10th of March. He submits that the matter may be adjourned during pendency of the at least for some time during pendency of this petition, for which he shall make a prayer before the certificate officials. Upon such a prayer being made before the certificate, before the appropriate authority, certificate officer, the matter shall be adjourned. Yes, Mr. Mahanti. Yes. Seti, not Eti. Seti kete. Beyond kete. 10 re achi.
10 30 mas.
30.
ঠিক আছে, shall be adjourned beyond 30 3 20 26.
30 টা actually week টা suffer from two adjournments, two holidays.
Beyond 30 right?
अच्छा.
Beyond 30 3. So, as would be convenient to the the officer in season of the matter. ଏଇଟା କେବେ ଗଣିବେ?
এটা স্যার উইক 6th কি 13th ଯୋଉଟା ରଖିବି ସାର୍।
ନାଇଁ ନାଇଁ ଆପଣ ଏପ୍ରିଲ ଲେଖୁଛନ୍ତି, ଆମେ ଆଜି ଏବେ ମାର୍ଚ୍ଚରେ ଅଛେ ନା ମୁଁ ଭୁଲ କହୁଛି ଦେଖୁଛି, ତ ସେଇ ଭୁଲଟା ମୋର ହଉଥିଲା। ଆପଣ ମାର୍ଚ୍ଚ
ହେଲେ
9, 16, 23
9, 16, 9 ତ ଆମେ ଅଛୁ 9ରେ 30ଟା ସାର୍ ଥାଉ।
23 ରଖନ୍ତୁ, ଗୋଟେ ୱିକ୍ ଆଟଲିଷ୍ଟ ଆଗରୁ ରଖନ୍ତୁ। The matter shall be listed in the week commencing 23/3/2026. The Lord Counsel for the State shall have liberty to obtain instruction. Liberty to have shall obtain instruction.
କିଛି ଦେବେ ମତେ
Lord, in fact,
it was Ashok Mahanti, Senior Advocate Mr. Bibhu Prasad Mahanti for the petitioner.
Lord, an electricity duty demand was raised on me. Well, I started a renewable energy power plant for captive consumption. Captive consumption. In accordance with the renewable energy policy protected by the Department of Energy.
But is it by Tata Power?
No, Tata Power. It is Odisha Cements.
No. Whose demand it is? That is interesting question. Mahanti, how you? I mean, younger Mr. Mahanti. The demand is by Tata Power. TPCODL. Something like TPCODL, TPNODL, TPSODL.
Yes. The demand is from Government of Odisha. Electrical inspector.
Acha.
Yes.
Okay.
ସେଟା ହଉଛି page 45 ପଲିସିର page 45ରେ ସେମାନେ କହିଲେ renewable energy projects will be treated as a new industrial unit. जो जेकौनसी existing unit ହେଲେ ବି ଯଦି renewable energy project କରିବ, it will be treated as a new industrial investment. All new renewable energy projects developed under this policy who come into commercial production within the stipulated period shall be exempted from having electricity duty for self-consumption for a period of 5 years. It nodal department corporation called Green Energy Development Corporation. हमको सर्टिफिकेट दे देने दे वी आर एंटाइटल्ड फॉर सच एग्जाम्पशन तापर सेटा प्रोसेस हेकरी जीवा कथा एनर्जी डिपार्टमेंट हम एनर्जी डिपार्टमेंट को लिखलु चिठी किंतु रेज करले डिमांड बारंबार अल्टीमेटली कहले ते तमे जाओ वो ये इंडस्ट्रीज डिपार्टमेंट किंतु कथा होची जे तापरे सेवन इंडस्ट्रीज डिपार्टमेंट कहला 2015 आईपीएल तमे आसुन इंडस्ट्री डिपार्टमेंट किसी करिया कथा नहीं कारण डिपार्टमेंट एनर्जी रे प्रोसेस करियो से किंतु समय आधार करला तापरे हमें गोटे सेक्रेटरी गोटे रिप्रेजेंटेशन देलु गिविंग द दैट वाज पेंडिंग. In the meantime, एनर्जी जो डिमांड टा थिला सेटा को सेना सर्टिफिकेट इशू कर देले
OPDR demand was raised initially. The first demand, any record, any issue notice or any determination? First demand.
सेटा तो हमें एडमिट करछु ना एति की एनर्जी हमें जनरेट करछु किंतु ताजोबा हमें एति की
कंजम्पशन एति की
कैप्टिव कंजम्पशन एति की हमें ये करू हमें देइछु बिल प्लान
they are raising the demand on the basis of captive consumption declared by you.
Yes. That is the dispute.
Now
क्या कथा जे एटलिस्ट एनर्जी सेक्रेटरी डिसाइड कला पर्यंत इश्यूटा ओपीडीआर एक्ट के स्टेट रहू. This is the only place.
Where is your declaration regarding consumption and
ସେ ବିଲ୍ ଗୁଡା ଦେଇଛ।
Just take again to page 45 is the where it says that in case of captive consumption, page 45.
12.4.
12.4. Concessions and taxes and duties. Correct.
4 C.
The senior page there.
Yes,
That one. Okay. 12.5.
All new renewable energy projects. First, renewable energy project should be treated as a new industrial unit. Has you got?
Yes, please.
Sir, got it?
Yes, I got that.
Then C all new renewable energy projects developed under this policy who come into commercial production within the stipulated period shall be exempted from paying electricity duty for self-consumption. Has you got it?
Yes.
For a period of 5 years from the date of actual commercial operation as certified by the nodal agency. Now, nodal agency is that corporation.
JEDCO.
JEDCO. ସେମାନଙ୍କର ସାର୍ଟିଫିକେଟ ଅଛି କୁଆଡେ ଗଲା?
ତାଙ୍କର they have approved in
ସେମାନେ ଯୋଉଟା ଆମକୁ ଦେଲେ ଯେ we are entitled.
annexure 2 annexure ସେଟା ହଉଛି 3 page number 84. Page number 84.
Yes. Page 84 annexure 3 proposal for setting up 7.3 megawatt.
Yes, with reference to the subject cited above, the state technical committee in its meeting held so and so date in principle approved your proposal for setting up this so and so solar
exemption.
Exemption.
This is permission to set up.
Yes. Thereafter the letter exemption letter hochi
commissioning certificate is at page 80.
Yes.
Then thereafter page 89 are the bills that we submitted that a bill ଗୁଡାରେ ଏତିକି ୟୁନିଟ୍ ଆମର ହେଇଛି.
Annexure 12 page
Annexure 12 not
132.
132, yes.
Page number 132.
Yes.
Here is the
here your Mercy will see Green Energy Development Corporation Odisha, that is nodal agency, with reference to the subject cited above, it is general DIC. It is to intimate that Sri Cement Limited has commissioned 7.3 power project at which was within the scheduled period of approval of STC. As per clause number 12.4 of the Odisha Renewable Energy Policy 2000, Sri Cement is getting exemption, is eligible for getting exemption for electricity for the period of 5 years. Additional Chief Engineer Electrical Cutter might the letter above intimated that the exemption application for electric duty may be processed as per the operational guideline of IPR 2015 as the Odisha renewal was linked with the IPR 2001. Now, City Cement made the and required documents for exemption will to them commissioning the captive power arrangement as attached for your kind information and necessary action. Then say ଆମକୁ କହିଦେଲା କିଛି ସେଗୁଡା ନ ବୁଝିକି ନିଜେ this is a operational guideline ଟା ଟିକେ ଆପଣଙ୍କ ଦୃଷ୍ଟିକୁ ନେଇ ଆସିବ. କାରଣ as you learn got to
yes, page 132
at page it begins
page 145. 145 is the operational guideline.
It at page 149.
Yes.
As you also got
yes.
The incentive, concession, and exemption, including grant of priority sector status under Odisha Renewable Energy Policy 2015, which are linked with industrial policy, will be applied for and processed as per the IPR 2015. The processing and operational guideline issued for their in respect of their eligibility, time frame, procedure, and format application. In case of any dispute regarding the eligibility or any other feature, the provisions of the Odisha Renewable Energy Policy 2016 will prevail. Yes. Such application shall be made to the nodal agency, and the nodal agency will forward all such application along with STC to the respective agencies for necessary processing.
So your argument is that after this letter issued by the Green Energy Corporation, nothing has happened.
No. Kuda.
That 132.
You are not coming under IPR 2015. কিন্তু এখানে কইলা
the response to 9824 letter of Green Energy Corporation.
they told that
Have they considered and passed any order?
yes, past order that you are not coming under 2015.
Which is that page?
Annexure 14, page number 144.
The application for exemption from payment of electricity duty on captive power plant with non-conventional source made by 67 under ETA is rejected due to following reasons. Reasons as per IPR 2015 ବୋଲି କରିଦେବା ଅଛି। କିନ୍ତୁ ଏଠି କହିଲା ଯେ ଏଠି ଯୋଉଠି କନଫ୍ଲିକ୍ଟ ଆସିବ ସେଥିରେ ନୋଡାଲ ଏଜେନ୍ସି ଏ ଯୋଉ STC ରେକମେଣ୍ଡେସନ সেটা তো আমার ফেভারে বি ଅଛି of the respective agency for necessary processing at their end. The nodal agency will coordinate with the respective agency for grant of incentive. Necessary agency will be Department of Energy. ସେମାନେ ଖାଲି process କରିବା କଥା।
Yes, while they if you can look at that rejection.
Yes, sir.
Have they referred to this renewable energy policy 2016?
Not at all.
Not at all.
So that I wanted the answer from you. Have they considered it in the terms of that?
No, no.
They have not considered.
Either you
take notice.
এইটা তারপরে লেকচার 12 টা
ଆପଣ notice issue করে object କରୁଛନ୍ତି ନା କଣ?
Sir, I'll replying your lordship's query, my lord.
ମୁଁ କରି କିଛି କରିନି ଆପଣ ତାଙ୍କୁ ବି କରିନି।
Here I want to submit some actual things and some law also. Some operational guidelines.
Notice issue କରିବାରେ ଆପଣ objection
objective. But so far as
so you reserve your energy.
One thing I may
because I can't
one thing will say the original this application is filed not under the OPDR Act, though a reference has been made on Annexure 17. They are challenging the demand of electricity duty. Your lordship may consider whether that is under the assignment. If your lordship says yes, then your lordship can take up this matter.
So I cannot say yes. Chief Justice has to say yes.
Seta electricity duty.
I do not have that.
সেটা আপনার নলেজ স্যার আনেছি whether it is assigned to
সেটা
যদি ইলেকট্রিসিটি ডিউটিটা ক্লেম করে কি চ্যালেঞ্জ করছে ডিমান্ড স্যার চ্যালেঞ্জ করছেন Annexure 13.
Yes. So with all respect to my কথা হচ্ছে if it has an electricity duty under the Act, Electricity Act, তার অপিল ଅଛି ଇଏ ଅଛି ସେ ଅଛି ସେଟାର assignment ସେ
ଆପଣ OPDR তে initiate କରିଛନ୍ତି ନା ନାହିଁ?
OPDR ସେ କହୁଛନ୍ତି ହେଇଛି ବୋଲି but challenging that.
ଆପଣ ଜାଣିନାହାନ୍ତି
challenging କରୁନାହାନ୍ତି main prayer is challenging the demand notice under Annexure
challenge not OPDR ହେଇପାରିବ।
The demand by the
ଆମେ
issues notice I have no objection to that.
ପାସ୍ କରିବାକୁ କହୁନି ମୁଁ ସାର୍ଟିଫିକେଟ ମୁଁ କହୁଛି let it be stayed
and so far as the rejection order the lordship will see Annexure 14 that is by the industrial department on the grounds that he is not eligible as per IPR 15. IPR 15
when I was reading, did you read it? When I was reading with them, did you read it?
Yes, I did.
Interestingly, they are not referred to though issue regarding electricity bill. They do not refer to the renewable energy policy 192000.
That is interlinked, my lord.
Correct.
I can say
interlinked bill means lekhichandi. Is it that they will not consider the
consider that is provision. If lordship permit, I can.
Who is not permitting you? Who is not permitting you? That they have considered the renewable energy policy. Where they have considered the renewable energy policy.
So far as the renewable energy policy, the petition of the prayer as per the provisions, my lord, this IPR 15 was the industrial policy.
Let us not jump around. You are saying that they have considered the renewable policy in rejecting that so that they have raised the demand.
Yes, my lord.
So where is that?
That is the three grounds they have taken in the rejection order.
Sir, where
relates to
you make it very simple.
Yes.
Make it very simple. Where they have applied this renewable energy policy?
Then your lordship may see the page 45, the first C, 12.24 C they are claiming. I am on A.
that says renewable energy project would be treated as new industrial unit within investment limit as applicable for MSME or page 45.
Rejection ଟା କୋଉ ପେଜରେ ଅଛି?
Rejection ଆପଣ refer କରିବା ପାଇଁ କହିଲେ page
ମୁଁ refer କରିନି, ଆପଣ କହୁଛନ୍ତି।
I am referring
Rejection ରେ 144 ରେ where they have discussed renewable energy policy ସେଇଟା ଦେଖିବେ।
renewable energy policy is
144 କୋଉଠି ଅଛି ଆପଣ କହିଛନ୍ତି ଯେହେତୁ କହୁଛନ୍ତି ଅଛି ବୋଲି।
Sir, 45 ରେ refer କରିଛନ୍ତି 45 ଟା they are relying on
144 ଆପଣ ଅନ୍ୟ ପେଜ କୁ ପଢିଲେ ମୁଁ କରିପାରିବି। I can only record that ଯେ
these are all
if sir ଆପଣ ଯୋଉ information ଟା ଖୋଜୁଛନ୍ତି ବହୁତ ଭଲ sir।
renewable
I cannot do that।
renewable policy is applicable to the industry of this type but different
ଆପଣ ଚାହୁଁଛନ୍ତି କଣ ବର୍ତ୍ତମାନ ନୋଟିସ ଇସ୍ୟୁ ହବନି?
ନାଇଁ sir ମୁଁ ମନା କରୁନି
ଜନମେଣ୍ଟ ଚାହୁଁଛନ୍ତି ନା
ଆପଣ sir no I am not saying that there are some issues
then why you are so I don't understand।
energy secretary जो representation ସେଇଟା ପଢ।
Next. My respect to submission was because they are not eligible, the grounds have been given, and that is supported by the policy.
Sir, have you read Gordon Das Bhanji?
No.
Election Commission versus
You cannot develop it under whatever the orders.
Standing on the way,
you cannot. Because you are a lawyer. You are not a henchman of somebody that will stand on the way.
I was just.
This is one of the cited decision by before this court by your esteemed senior. He always cites this. He doesn't cite Gordon Das. He cites the state of Punjab that Mohinder Singh.
Yes.
So you are just arguing just opposite to Mohinder Singh and Gordon Das Bhanji.
No, I am
saying because everything is interlinked. 144 does not contain. The question is very specific. With my limited ability, I try to raise very specific so that easier for both the counsel. One senior is there. His assisting counsel is
not eligible. They are not eligible.
So that who will say by interlinking the annexer?
Unless they are eligible for the industrial policy, they cannot take benefit of that energy.
What you are saying?
Energy policy came in 2016.
Yes, sir.
IPR came in 2015. Then
you must understand what you are saying. Even to that extent, they have not said.
No.
If you read 144,
15, IP 15 is different than energy.
That extent, I also make good speeches. But I had to go to the record to say something. That is, it is not that I can
only see
144. You are saying that 144 because it is interlinked. Even that reason they have not used.
No, they have used that. Yes, 44 certificate.
Sir, 144
yes, 144.
I am referring to 44. No. So kindly go through that Gordon Das Bhanji and Mohinder Singh.
They have said in 3 paragraphs rejection order why they have rejected.
Correct, sir.
Yes. Where I have gone through that IPR.
Sir, which is applicable. Sir, very good. Then you are so studious, you go through. But 144, where they have referred to relied on the energy policy to reject the contention, the claim. Because it is a claim. Because the problem is now, if you make it is a claim under IPR 15, it is worse for you. Because they don't say.
They say at page 44, they have said.
You will not listen, that's the problem. You will not understand. 144 is the rejection. They don't say that we are rejecting on 144 on basis of IPR 15. Now you saying, suppose I will record it. I'll record it, no difficulty. But that creates more problem for you. Because which is not there on record, and they cannot, so they will not be able to, substantiate that.
No, I am saying
you must have to, instead of making an extempore summation, you should have a counter.
Sir, I am relying on
you are an officer, you are a lawyer. Let them file the affidavit.
They will file
that is extempore submission that of course nobody can prevent. The consequences understand.
Yes,
because now you have to record your submission.
I am relying on 12.4a. That's the only submission. I am not making any
record. You have said, trust me, if you allow me to dictate, I will dictate. I'll record your submission that you are relying on page 45, 12.48.
Yes.
Yes, I'll record that.
That part I am
So that creates more problem for you than solving the issue. Because nothing is on record, pleadings are not on record. Whether they have relied on 12.4, whether they have relied on Constitution, whether they have relied on Bible.
Your Lordship, my
Kindly listen, sir.
Yes.
Please, all of you, you know so many things, you are so erudite. But judge is not that erudite, he has to complete a sentence. Just ask them, they should file that affidavit that we have.
I will ask.
So don't become the officer yourself.
No, I
have relied on 45A, page 44. They have not said so. Well, and that is why perhaps you are not looking at even 144 before submitting this.
No, I have retail.
So 144 kindly look where they have said they have relied on 45A. They have not said anything.
This is a beneficial legislation while passing by the industry department when they say that under the industrial policy they are not eligible. If you has a case on he applies in renewable policy 16. Installs a captive power plant. You give a permission. Yes.
He starts the power plant.
Yes,
Then he approaches the electrical inspector.
Yes,
electrical inspector issues a certificate.
Yes.
Then he approaches the authority corporation, which is your corporation. They send it. Then somehow you forget everything and because maybe your advice, you appear in sugar electricity matters. I do not know. How you are so confident in about the facts also I cannot say.
Eligibility.
Nothing is on record.
You know, issue notice, they will file that.
No, you are not doing any favor to the court.
Saying that we are doing.
Why are you saying what is this kind of submission? If you prefer objecting on record or objecting, you have to take a clear stand. If you want objection, I'll record your objection. Why this is to be
objecting for
notice? What is the point in making a submission?
I am unable to even place this matter before a lordship taking the otherwise. I am not there.
No. It is after the matter was heard extensively.
Lordship may not all this.
By the Lord Counsel, Mr. But I have to record your submission. Then I will say that I will not take up this matter because you see, this is a personal aspersion and the Lordship is not allowing.
No, not personal. Even personal. I am showing your Lordship 12.4A.
Sir, I have seen that. I have told you I have seen that 12.4. I said because I am also when they placed 12.4A. I read it.
It is not placed. That is why that is my endeavor.
Then Mr. Mohanty, I'm sorry, I have to draw a line here.
No.
I have to draw a line here. I'll record your submissions and.
Lordship, issue notice from the vehicle.
Favor to.
Favor.
এটা রেকর্ডিংটা রাখি দিবে রেকর্ডিংটা রিটার্ন করি the petitioner is before this court challenging the demand made by the opposite party number 2. The petitioner is a company registered under the Companies Act. Is before this court. Challenging the demand made by the opposite party number 2. The bracket annex 13. That is letter dated 10/9/2024, 23/10/2024, 10/1/2025. Mr. Mohanty, you take your seat. I'll just take some time to dictate the order. Or if you're comfortable standing, I don't mind, but don't need me. Mr. Sahoo, can I request you to take your seat?
Yeah.
Kindly take your seat. The learned senior advocate refers to the learned senior counsel appearing for the petitioner refers to Mr. Mahathir asked that which Mr. Sahoo says that it does not place. What is that?
It is 12.1 at page number 45.
At least that was placed twice.
12.4A.
Reliance refers to 12.4 contained in page annexure 1 ରେ ଅଛି, page 20. Renewable Energy Policy 2016. The relied upon paragraph 12.4 is reproduced herein. Referring to 12.4A, they submitted that the petitioner company is entitled for the benefits for establishing captive power plant, captive solar energy.
Yes.
Captive solar energy power plant.
We are relying on 12C.
On 12C that.
We are relying on 12C. They are relying. Yes.
He relies on 12C.
Yes, 12.4C.
The learned senior advocate then refers to the process of establishment of the captive solar power plant. That is series of letters to the Green Energy Development Corporation of Odisha Limited, dated 15 July 2022. Which culminated in establishment of the power plant, which culminated in approval dated 21/9/2022 into bracket annexure 3, issued by the Green Energy Development Corporation of Odisha, which is a wholly owned subsidiary company of OHPC Limited, Odisha Hydroelectric Power Corporation Limited. Thereafter, the commissioning certificate was issued by the Gridco Limited on 27/10/2023 into bracket annexure 5. The generation and consumption of electricity from the captive solar energy power plants of the petitioner company is annexed to the writ application marked as annexure 6. Six series rather. Six टा सब गुड़ा का गोटे starts with 89 to 97 तो गोटे document नो
81 to 97.
Pages 81 to 97 bracket लिखी थी.
89 to 97.
Yes, 89 to 97.
Yes, yes.
But that is not one document, that is different.
Different months.
Different months.
Yes.
For different months, comma for different months कर दियो.
For different periods.
For different periods कर दियो. Thereafter, the exemption application was sent. The commissioning of the power plant was intimated to the Chief Executive Officer, Green Energy Development Corporation Odisha Limited. So that upon short GEDC date by letter dated 20 July 2023. the GEDC by letter dated 16/8/2024 forwarded the application of the petitioner company for exemption of electricity duty. देखिए लिखी ना पेज 101 रे अछि exemption of electricity duty to नेकी regarding पर्यंत. Thereafter, the general manager DIC, the GED
Assistant Director.
That is page 132.
Yes.
Thereafter, the GEDC wrote to the District Industry Center, to the General Manager, District Industry Center, Khapuria, by letter dated 9/8/2024. With the following subject. Exemption of electricity duty, page 132 re achi, up to regarding. Para. Any other document you referred for then 149 you referred?
Eta exemption lagi auta refer itla annexure 9 ta. Seta seven ଦେଇଥିଲେ additional chief engineer come electrical inspector first letter.
The first insert karibe. By letter dated 16/8/2024, the GEDC wrote to the additional chief engineer come
16.3.
Right, 16.03.2024. The additional chief engineer come electrical inspector, Central Zone Bhubaneswar, was written by the GEDC, enclosing letter, not enclosing, with reference to the letter of the petitioner corporation regarding subject exemption of electricity up to regarding. Para.
That CA କହିବେ ଏଇଟା process କର through it.
That is page?
ସେଟାଇ ଏଇଟାରେ ସେମାନେ କହିଲେ annexure 11 3/7/2024 process karo 2015 under
In the letter dated 3/7/2024 into bracket annexure 11, the additional chief engineer come electrical inspector Cuttack. They are all of them are parties made parties.
Yes.
Party the pocket. Additional chief engineer come electrical inspector wrote to the additional assistant general manager electrical GEDC to process the exemption application as per the guidelines vested in IPR 2015.
For granting exemption.
For granting exemption
at this end with the 7 way.
Under Orissa Renewable Energy Policy 2016. Thereafter
ଏଇଟା ଆମେ Green Energy Development Corporation process କଲା ଏଇଟାକୁ DIC କୁ ପଠେଇଲା.
DIC ଗଲା ତାପରେ
Annexure 14.
Annexure 14 ରେ DIC କହିଲା ଯେ you are not coming under 2015.
By letter dated 23/10/2024 of the ACE-COM-EI Cuttack, the petitioner company was intimated that they are not coming under the
23/10/2024 demands गुड़ा raise कर दे सवाल.
ଆପଣ ଏବେ ଯୋଉଟା ରେଫର କଲେ ସେଟା କୋଉଟା?
କୋଉଠି?
3/7/2024.
Page
number 130.
Yes.
11.
সেটা আপনারা লিখলে তো
সেটা
লেখা হয়েছে।
Thereafter, annexure 14. Page number 144.
Annexure 11 आप तो लिखी दियो तो by letter dated 3/7/2024 the office of additional chief engineer cum electrical inspector Cuttack wrote to the assistant general manager electrical GEDCOL, it's a short form there, which indicates the following: the operational guidelines on the Odisha renewable energy policy 16 to Neki up to granting exemption at this end.
He himself raised the bill.
Thereafter,
page 132. 9/8/2024. Forward कला से DIC. Green Energy Development. Annexure 12.
that is there. Actually, when I dictated, it was not serially, but I have considered this. So the last order you are challenging, that is 144.
Annexure 13 series.
So that reasoning where they have said 144, I think.
144.
144. From the Energy Department, the matter was referred to the Department of Industries. Thereafter, the Additional Director of Industries, by his letter dated 17th April 2025, rejected the application of the petitioner company seeking benefit of the, what is that, 2016?
Energy policy.
Of the Renewable Energy Policy 2016. Odisha Renewable Energy Policy 2016. It is submitted that while rejecting the application of the petitioner, apart from referring to the IPR 2015, which is prior to the Odisha Renewable Energy Policy 2016, the renewable energy policy and its implication have not been considered by the authority.
CA considered Kariwani. CA, he is only the forwarding agency. It is beyond its jurisdiction. সেটাও তো আমি চ্যালেঞ্জ বি করনু।
Who is to consider by 2016 policy?
Concerned agency মানে energy department.
The concerned department has not considered or has been consulted for rejecting the claim under the Odisha Renewable Energy Policy 2016. I'll correct that. It requires repairing. Actually, since I am actually withdrawing myself, that's the problem. Now, because after in good faith you proceeded, so now at this stage, the court directed for issuance of notice. The learned Additional Standing Counsel, Mr. P.K. Sahoo, made his submissions. When he was asked whether he is objecting to issuance of notice to the opposite party, he submitted that, which forms part of the recording of the 2 days proceeding, that no, he submitted that he is only answering the issues raised before this court. He submits that. The page 45, the Odisha Renewable Energy Policy 2016, paragraph 12.4. A was not placed before this court. The authorities have relied on the said paragraph to reject the claim of the petitioner company for exemption. On being asked whether at page 144, the additional director of industries, where he has given reasons for rejecting the exemption application, has referred to the said paragraph 12.4a or any reason to substantiate his decision regarding rejection of the benefit for renewable energy policy 2016 claimed by the petitioner company. It is submitted by the Learned Counsel for the Learned Additional Standing Council that they are linked. In the context of the legal issues raised before this court, the Learned Additional Standing Council was asked whether he has gone through the decision of the Supreme Court rendered in Commissioner so and so versus Gordhan Das Bhanji, reiterated in Chief Election Commission versus Mohinder Singh Gill, wherein it has been laid that the order passed by any authority in the administrative domain has to give reasons, and the order must speak for itself. He fairly submits that anyway, so the lekhuntu. ଆପଣ କହିଲେ ନାହିଁ ବୋଲି ଆପଣ ପଢିନାହାନ୍ତି ବୋଲି କହୁଛନ୍ତି
ସେ ଆର ଜଜମେଣ୍ଟ ଯୋଉଟା କହୁଥିଲେ ସେଇଟା କହିଲେ ବଟ୍ ଆଇ ଆର ମହେନ୍ଦ୍ର ସିଂ ଗିଲ୍
Gordhan Das Bhanji
ସେଇଟା ଆପଣ କହିଲେ ସେଟା
he submits that always is obstructed by this court
no that I have
for making submissions.
No, your Lordship may not.
The recordings of the today's proceedings are placed on record. In view of the personal grievance raised against the judge,
that I have not made your Lordship recording.
Kindly replay it so that he can.
I have said your Lordship not allowing that part only.
In fact, you said you never allowed to.
It's not the intention of your Lordship recording. I'm sorry for that.
So this court considers it appropriate not to proceed with the matter. When the order is dictated, the Learned Council's Additional Standing Council, Mr. Sahoo, submits that. You never intended that.
But that is not my intention.
That it was not intention, though he said in so many words, it was not his intention. Stop. The difficult part is that whatever was said in open court, it forms part of the record, and the proceeding being in hybrid mode, everything is on record. It would be apt and appropriate for matters where Mr. P.K. Sahoo is appearing should not be placed before this bench. The said aspect shall be placed before the registered judicial, deputy registered judicial. Yes.
That part once I said, Lord, as that was not my intention, your Lordship recording.
No, you should get a fair.
I know. I have.
When the judge is
intentional. That I have something to say.
I think you can ask the entire bar members whether I have obstructed you. Whether notice also, which I should not also.
So our was not
issuance of notice. For issuance of notice, the others.
I said I have no objection. I said I have no objection.
So after, but you continue.
But I only
continued your bad
early on my senior's placement. I was only to reply. Then it is up to
you are never asked, sir. Because you are not the additional secretary. How can I ask you reply, Mr. Senior's? He is placing record for issuance of notice.
I have to enlighten your Lordship, assist your Lordship.
In case of a fresh admission matter. You must wait the
question is raised.
Suppose the case is not entertained.
It will affect your Lordship on the fact also.
Sir, can I decide now? I'm
saying, that is why I said I never objected that your lordship is notice. Only I was showing that the reasons is there and that is the ambit of this.
One thing I can tell, sorry, because I didn't know that this will take this turn. You have almost spent more than 2 hours.
I beg apology, my lord. I never intended to hurt your otherwise, or I have any intention otherwise. Only I wanted to place that part.
Also for the Lord answer, standing counsel, Mr. P.K. Sahoo repeatedly says that he begs apology. He did not beg any apology, nor he is supposed to beg apology before the court for anything. Whatever has happened is a matter of record. Nobody, at least the court does not request or ask him to beg any kind of apology in any manner. Why should I ask you for apology?
Your lordship, withdrawing myself from your lordship's court.
No, I have withdrawn. I have withdrawn myself. You are not there. It is a.
I'll lose my chance to argue before your lordship.
Sir, I do not. I have withdrawn myself. Then again I have to record. If I record, then again there will be another lengthy order. I have not withdrawn anyone. When you say that I am not allowing you to submit, because you see, at least I have little bit of experience that side for issuance of notice. I have. In fact, my reading of law is that the other side need not be heard. It is between the petitioner and the court. And when exercising 226, the widest of jurisdiction.
No, I have never obstructed your lordship to passing any order or issuing notice. That I have also said, my lord, open court, my lord. Only I wanted to bring your lordship's 1-2 lines.
Sir,
I have not even said anything.
Whatever you have said, I have recorded because I did not also. Because for issuance of notice, I did not. I have faced tough judges also. It is not that I have no experience.
I'm sorry. Extremely sorry to have.
So I don't know. I should beg apology because you waited since I think 12. 12 now it is 3:30. 3.5 hours.
Cases doesn't matter.
Yes.
One case.
Yes. Yeah, that I did a Saturday. Yes, next. So Arjun Charan Behra for the petitioner. Yes, who is appearing in this?
I am afraid.
Arjun Kodde.
My lord.
So Behra Arjun. Some other day. It will be embarrassing for me also. Because he has been assigned the briefing. But a date कर दी परिवे क्यों दिना? अपन
सोमवार रोज
सोमवार ही परिवे ना क्या अपन सोमवार नॉन है बनी?
ना ओरिजिनल में छुट्टी आवे डेट सॉरी जानता है
आज ही let us
मंगलवार ना
ठीक है देखो the week commencing आज ही तक तारीख
आज 7 तारीख
तो week commencing नहीं कोई दिन में असले हवा कोई दिन में adjust करते ठीक है हाँ ठीक है ना yes Mr. S.K. Dwivedi
आज थाउ ना लागी
ठीक है
आज मत
नहीं एथिरे तो आपन डिफिकल्टी नहीं काहे कि ना सेथिरे मिस्टर बेहरा को
I know but
आपन को is a
private
is not party
private matter yeah lordship.
When do you want Mr. Dwivedi?
Any date your next week any date.
Okay, date कर दो.
Yeah.
तो आज कर दो लाइव से
कितने तारीख को कोर्ट मास्टर
appearance memo Mr. Mahanti Mr. Vibu Prasad Mahanti on it
next week
files appearance memo of Sir Ashok Mahanti for the petitioner. The appearance memo shall be taken on record, stamped copy the update. Yes, next. Date कर दो जोटा आपन सुविधा में कर दे क्विक करंतु
next 20 21
yes please.
On behalf of Mr. Ratha, I want to submit that there is a noting on the cause is that 2 numbers of defects are not.
Sir, your name?
Vishwajit Ratha. So need and short.
नहीं.
नहीं again.
So Vishwajit Ratha on behalf of PK Ratha, item 21. Mr. Biswajit Ratha on behalf of PK Ratha for the petitioner. The learned counsel for the petitioner seek further time.
Removal.
How much time, sir?
Removal of defect.
Kiti dina?
1 week.
Seeks further 1 week time to remove the defects pointed by the SR.
Okay.
Prayer is allowed. The matter shall be listed in the week commencing.
33.
Orders matter na এটা. Orders ଗୁଡାକ ଜାଗା ନାହିଁ ଆପଣଙ୍କର? ହଉ ଠିକ ଅଛି।
Okay.
30 ଦିନ ନା ଆଜି ଦରକାର?
ଚଳିବ ଆଜ୍ଞା।
30 ଦିନ ଠିକ ଅଛି।
Obliged.
Yes, next.
Rotate to
Please, Your Lordship, item 22. I filed an application for
Mr. Vivekananda Jena for the petitioner.
an IA for conversion, Your Lordships. I challenged the order rejecting
Staff reporter has said that it has to be converted.
Aye. The judgment भी अच्छी
IA number लिखिए 2958 of 2026. The IA has been filed for conversion of the nomenclature from WPC to MATA. The learned counsel for the petitioner refers to the stamp. এটা লেখা হয়নি এসআর ହେଇଛି ଦେଖିଲେ এটা এসআর ବୋଧେ ହେଇନି ଏସଆର କରିବା ପାଇଁ ଅର୍ଡର ଅଛି 10/2 पर ଏସଆର ହେଲା କି ନାହିଁ ମିଷ୍ଟର ବାରିକ ଦେଖିବେ ଟିକେ ଫିଜିକାଲ କପିଟା ଦେଖି ଦିଅନ୍ତୁ ମତେ ଦିଅନ୍ତୁ ପାଇଲେ ଆପଣ ବୁଝିଲେ କଣ 10/2 ଅର୍ଡର ପରେ ଏସଆର ହେଇଛି କି ନାହିଁ ଦେଖନ୍ତୁ ମତେ ଲାଗୁନି ହେଲା ଭଳିଆ By order dated 10/2/2026, the submissions of the learned counsel for the petitioner were noted, and the matter and stamp reporting was directed to be done again. Pursuant to the ହେଇଛି ତାପରେ
ଆଉ but I am relying on a judgment.
No, the problem is that nomenclature is not part of my. It is for the
stamp report.
The method of High Court rules. High Court rules. Only no? Done again. As it seems, the stamp reporting has not been done. The matter shall be placed before the registered judicial to do the registered judicial to do the needful with reference to the order dated 10/2/2026.
ଖାଲି ଗୋଟେ କଥା ସେଇଟା ଜଜମେଣ୍ଟ ଟା ରିଲାଏ କରିଦେଲେ they will follow.
ସେଇ ଜିନିଷଟା ଆପଣ ତାକୁ ଯଦି ଟିକେ ଯାଇକି the learned counsel for the petitioner shall do well to inform the stamp report regarding the judgment of
this honorable court.
But the problem is that if it is even if the judgment SR after SR it may decide that, but before the client ଟା କାଟି ଦିଅନ୍ତୁ
Similar matter maintenance.
ଯାଆନ୍ତୁ ତାଙ୍କର ସେ କରିକି ଦିଅନ୍ତୁ ଆପଣ yes it is their job should do it. ଦେଖାନ୍ତୁ ମତେ ଦେଖାନ୍ତୁ ଟିକେ ମୁଁ ଆପଣ ତ କହି ଆପଣ ମତେ ଦେଲେନି record received from the court without order. Upload ହେଇନି ମୁଁ କେମିତି କହିବି ଆପଣ ତ ମତେ ଦେଖାଇଲେ ଆପଣ ଦେଖନ୍ତୁ ତାଙ୍କୁ ପଚାରେ ଅର୍ଡର ଅଛି ଆପଣଙ୍କର 10-2 ଅର୍ଡର ନାହିଁ
10-2 order ଟା ମୁଁ କାଢିନି
ଆପଣ ଦେଖିଲେ ସେ କହୁଛନ୍ତି କଣ ଅପଲୋଡ ହେଇନି ବୋଲି ମୋ ବ୍ରିଫରେ ଅଛି 10-2 ଅର୍ଡର ଅଛି ଆପଣଙ୍କର ଫିଜିକାଲ କପିରେ ଅଛି ନା ନାହିଁ ଫେର କଣ ଆପଣ ଆଜ୍ଞା କହୁଛନ୍ତି କଣ ଏମିତି ଆଉ ହେଲେ କି ଆପଣ ମତେ କହିବା କଥା ଆପଣ ନିଜେ କନଫ୍ୟୁଜ ହେଇଯାଉଛନ୍ତି 10-2 ଅର୍ଡର ଅଛି ସିଏ ହୁଏତ ଅଫିସରେ ଦେଖିନଥିବେ ସେଟା ହେଇପାରେ ପସିବଲ ତାଙ୍କ ଅଫିସ his office note what he is showing office note says that the record is received without any order but there is an order he also finds it तो देखिए नहीं मतलब डाकी कहबे जेटा भूल ହେଇଛୁ yes list in the week commencing 30 दिन पसंद अब ऑर्डर सुडा को 30 दिन सब 30 दिन हबो ना आउरी आगुरु एटा केबे केबे कोन तो 23 दिन we commencing 23 दिन सेतरे से वीक 80 टा मैटर पोस्ट करछन आपण बैलेंस करू नांती ऑर्डर्स फ्रेश एडमिशन यस पास ओवर किछ रहला